ನನಗೆ ಸುವರ್ಣ ಸಾಹೇಬರು ಏನ್ ಸರ್ ನೀವು ಜವಾಬ್ದಾರಿ
The speak you got again. There is
who's the respondent? Who's the respondent? Survey copy on the mind. Interim order in code. Okay, next week after.
They are, despite rejecting the appeal filed by the respondent, the deputy commissioner is now intending to make an entry in column number 11 of my.
And it wait till Monday.
Yes, Monday. Great. Page number 10, number 38 to 40, page number 11, page number 41 to 46.
Number? Hearing on I, you have to wait, you can't move hearing on I. You can't move hearing on I matters. Please wait.
Number 12, number 47 to 51, page number 30.
Lord, serial number 50, please.
Yes.
Lordship, may kindly have it on next Friday, Lord. I'll need some time to prepare on some points.
Please.
Serial number 34, my lord.
Grateful.
Hearing on IA, please wait.
Page number 30, number 52 to 56. Page number 14, number 57 to 59. Page number 15, number 16 to 64. Page number 16, number 65 to 70. Page number 17, number 71 to 76. Page number 18, number 77 to 83. Page number 19, number 84 to 87. Page number 20, number 88 to 91. Page number 21, number 92 to 96.
This number 2, I'll have it relisted on Monday unless there's Gurvara. Next Thursday. List will be repeated on next Thursday. The instructions are to post it, repost it on next Thursday. The entire list come up on next Thursday.
interim order needs to be extended. Not in serial number 1, second list serial number 1.
Well, interim order. All right.
Please.
President, morning, you also have to Monday.
Hearing Vinay, you can't move. Please wait when the matter is called.
Lord, I appear for the petitioner. Lord, the matter pertains to retrospective promotion, Lord, to the post of assistant engineer. Lord, I was eligible and qualified for being promoted as such in the year 2015, and my juniors were all promoted.
Relist on.
Serial number 2.
PJ to take notice for our issue notice to our.
3. Ramchandra.
Notice to order. PJ to take notice for our one. Sumana Baniga.
Yes, Malik.
PS Manipal to take notice for our to relist on. Office objections come here, madam. Office objections come here.
Number 4.
Next year. Then at AGA to take notice for respondents 1 and 2. CMC Naga to take notice for R3 and R4. And AGA to take notice for R1, R2 and R5 to R9. Naga to take notice for R3 and R4. There should be an interim stay in terms of the interim order passed in WP 16601/2023. Post along with WP 16601/2023.
Number 5.
Next year. N. Page. You notice. Then at AGA to take notice for respondents 1, 2, 3. She Naga to 1, 2, 3 and 4. She Naga to 1, 2, 3 and 5. Naga to take notice for R4. Respondent shall not disturb the petitioner from their service if they are working as on today. Post along with WP 14470/2023. ಸಿಗ್ತಾ ರೆಕಾರ್ಡ್ ಸಿಗ್ತಾ ಡೇಟ್ ಕೊಟ್ಟು ರಿಲಿಸ್ಟ್ ಡೇಟ್ ಕೊಡ್ತಾರೆ ರಿಲಿಸ್ಟ್
Wanted to know more about the response or not about the Page 44. Page 44 of the document you have furnished.
Yes.
What penalty can impose, what penalty can't impose, the way is indicate. Why not exceeding 10,000? Why shall ensure these two is the authority not decided under this. It's when the time he was retired, when the time of submitting the report, the petition report, this court was retired in 2013. But the matter was there before the syndicate, not three times syndicate, taken decision. After considering this report, after considering the objection quite well.
No, his argument was under this H,
Yes.
8H alwala,
Yes, yes,
13H.
Yes, this is submitted back to that, they have received the report, and completed their explanation. The explanation was considered in the meeting, of the syndicate. What is this argument is one, non-consideration of the report, reply given by the report. And other issues, which are not report, syndicate has come about, that is his argument.
The reply was given by him to the report.
Yes,
The vice chancellor was required to consider that report.
yes, that has been considered, because the why the reason was,
Where is the consideration was what we asked?
you get reason for making, referring the matter to the syndicate to law.
I understand that
Is also a chairman of the president of the syndicate.
that is immaterial.
That's
The
one.
the VC should consider the representations
Yes.
and then place it before them. After he comes to the conclusion, yes, the report has to be accepted. He will then place it with the syndicate for imposition of a penalty. Was that done by the vice chancellor?
Here may not, vice chancellor did not take any decision in the matter for the reason. The report of the committee itself is not make any decision, it impose a higher penalty. Therefore, vice chancellor thought it to refer the matter to the syndicate, because he has no power to impose lesser, higher punishment. Basically, see the report for the moment, report. Otherwise, he would have taken decision in that. Report of the committee not to impose penalty, higher penalty. I discussed with the concerned authority.
Where is the report? Page number?
Record is there at page 24. 24. Recommendation at page 34.
But Rajeshwar, if the syndicate is a higher body than the vice chancellor, the consideration of it can't be said to be irregular. I can understand somebody lower than the vice chancellor considering it.
He also says so.
Statute says that it is the vice chancellor who
Alright.
can decide.
But the vice chancellor,
Representation.
vice chancellor is a part of the syndicate. Syndicate is a higher collective body. If they take a decision, then it's better than one person making a recommendation, isn't it?
My lord, whoever ultimately, my lord, somebody has to listen to my arguments. Nobody has listened to my arguments.
You know, your arguments were in the form of your representation. That was considered by the syndicate and order was passed.
Everything is considered. My lord, set page 16, 17. Page 17, that is the consideration.
17 of?
The document which my lord have, which my learned friend passed.
Yes.
Keep on. The syndicate has considered the report of the university complaints committee given against Swartz. The syndicate has.
That is a decision. The earlier page, I think 16,
My lord.
is the consideration. Syndicate has carefully considered the report of the complaints committee and it agrees with the findings of the state of the representative submitted by so and so is also considered by the syndicate. Most of the objections raised by him should have been raised before the complaints committee. The other objections do not warrant any interference. So they have considered it.
Any pages in my reply.
In pages,
They simply say all these things we should have submitted before the committee. And they say that the other things we cannot, they have considered and they.
I think the best thing is to issue rule and let the matter lie at this stage for some more years. Natural Mugidid. What do you want me to do? I'm satisfied that there's a consideration of your representation.
Serious allegations are made. This is
No,
the
but
way the matters
it
are
is
considered.
it is backed up by that victim's statement herself. So what more do you require?
Victim also says that no one pursue the matter.
No, 15 has
After the committee has
there is a
considered, after the consent is evident before the committee, thereafter I have been shifted, some other guide has been given to me, I don't want to pursue that.
No, but that particular act, being a person in that position against a student is rather serious.
That is recorded
I
in
just
page
was
25.
the section 10 of the new act, of course, that act was not there. Ultimately, for us, conciliation proceedings should be taken into consideration before any last decision is
But
taken.
a teacher acting like this against a student,
11 witnesses were examined, not a single person for us has spoken ill against me, including the lady in his
Yes.
case.
the victim has spoken against you. That is what is important. You may be a very good person to others, but insofar as this particular student was concerned, the allegations made against you is rather serious and not very.
Yeah. Something more also happen and things people let them go. Here she wants to let it go. But the other
Understand,
people just want to take it
A
up.
co-employee can understand, but against a student,
Page 28, she was
Okay, but
sorry
you
to
know,
the student.
now, Alas kindly say us how I have explained in my objections, how the committee has done.
I'll issue rule. Issue rule.
Number 8. 14. Number 8.
First one by is
Opposed. ಏನ್ ಮಾಡೋದು? Page?
Forward. APPCL. Take necessary action.
Is there any decision taken to hold an inquiry against him? Then, then you are holding him guilty without even holding a charge.
But it would not be that we're holding in the, maintain administrative harmony so that there's no function of the.
Now, suppose this complaint that you received was incorrect. Is it not the complaint that you received against him? Suppose it is found to be untrue. Are you not punishing him on a false complaint?
It is not that we are punishing him, not that.
Then what else is this? Because the direction is to post him in any place in North Karnataka.
No, but they are not posted, now he's posted to Chikmagalur from Bangalore. With working in Westcom.
No, I can understand if you're going to hold an inquiry, then this order is justified. Without holding an inquiry, how can you? Then I'll pause this.
If your lordship kindly seems to that we have 7 orders. Serious number 4.
And no reasons are recorded. They are not placed before the chief minister. Those reasons are not placed as to why you want to transfer.
And then forwarded to the file.
Like ದೂರಿನ ಏನಾರು ಹೇಳ್ಬೇಕು ತಾನೆ reasons for the transfer should be. If you go back ದೂರಿನ ಮೇರೆಗೆ ಅಂತ ದೂರ ಓದಿದ್ರೆ it is on the basis of a complaint of a co-employee.
We have received complaints and based on that letter has been addressed by.
But do you think this is the correct procedure that somebody gives a complaint and
But inquiry has to be carried out, not what happened.
then this is a classical case of a punitive transfer? On what basis? What is the complaint? Adalita Drupayoga. It can be anything.
Not by one of the other
All the more reason. You know how they work. You can understand some kind of a financial misappropriation, some misconduct, which is relatable to his discharge is one thing. Co-employee says he is abusing his powers. And I'm with you, I think you should not. Want me to quash it or do you want me to say it? What do you want? Bernard, counsel for KPTCL files a memo and encloses copies of the note sheet and tippani andre note alla in a summary and note of the speaker as well as the communication of the government and the transfer proposal. It appears from these documents that the petitioner was transferred since a co-employee of his had given a complaint that he had misused his administrative powers. The complaint does not indicate as to what was in what manner the petitioner had misused his administrative powers. And on the basis of such a complaint, the speaker has addressed a letter to the Chief Secretary, Additional Chief Secretary of the Energy Department, suggesting that the petition be transferred, and accordingly, the government has issued a direction to take appropriate action and submit the report. Thereafter, a transfer proposal has been submitted and the same has been accepted. The same has been approved by the Chief Minister and consequently an order of transfer is made. Since there are no reasons recorded for the transfer apart from merely stating that there was a complaint, in my view, this would prima facie amount to a punitive transfer. That will be matter, it will be appropriate to stay the operation of annexure D insofar as it relates to the petition. No, I am prepared to quash it right now because you wanted time. This only says for effecting a transfer, there need not be any inquiry conducted to first ascertain. So even on just a letter, you will transfer. The guidelines stipulate if you want to do a premature transfer, you should record reasons. And that reason, where is the reason recorded? No, the Chief Minister is supposed to look at the reason and then approve that reasoning. If there's no reason, then how is it going to make it? I think you should advise them at least to send a proper proposal. The guidelines are clear. I mean, if you don't follow the guidelines. Last notice was there to take notice in the last occasion and check your instructions. It was accordingly filed a memo to them starting now.
I'm hearing for the respondent. It is await as per the order sheet, but it is still the notice is awaited.
And direct matla ನೀವು ಕೊಡ್ತೀನಿ ಅಂತಂದ್ರೆ ನಾನು ತಗೊಳ್ತೀನಿ ಅಂತ ಅಂದೆ. Yes, Mahesh files a memo and also encloses the copy of the original general power of attorney and the basis of which he had entered appearance in the last occasion. Said memo is taken on record. The office is directed to keep this document in safe custody. Released after service of notice on R5. Interim order granted earlier shall stand extended.
Then, how will be?
Huh? The cost date amendment ಮಾಡ್ರಿ first.
Respond number 1 and 2.
ನೋಟಿಸ್ ಸರ್ವಾಗಿಲ್ಲ, ನೋ ಸರ್ಚ್ ಪರ್ಸನ್ ಅಂತ ಬರ್ತಾ ಇದೆ. Then council submits that he had addressed the retirement notice to the petitioner and the same has been returned on the ground that there is no such person residing in that address. So he submits that he has no instructions and therefore he will permit to retire. In view of the fact that the council, the petitioner would have no way of ascertaining the address of the petitioner, the retirement notice sent by him is accepted and he is permitted to retire. Release the matter showing the name of the petitioner in the cost date. Because this.
The petitioner, my lords, is about, my lords, of the professors matter, my lords, Urdu professors matter, my lords, who was asked to, my lords, get PhD.
ಏನ್ ಮಾಡಿದ್ರೆ? ಯಾರ್ ಕನ್ಸೆಂಟ್ ಲೆಟರ್ ಕೊಡ್ತಾ ಇಲ್ಲ? ಕನ್ಸೆಂಟ್ ಲೆಟರ್ ಏನು?
ರಿಕವರ್ ಮಾಡಕ್ ಕನ್ಸೆಂಟ್ ಕೊಡಿ ಅಂತ.
If he gives consent, that means he is accepting that he is at fault. ಎಷ್ಟಿದೆ ಬಾಕಿ? ಅಲ್ಲ, ಅವ್ರ ರಿಟೈರ್ಮೆಂಟ್ ಬೆನಿಫಿಟ್ಸ್ ಎಷ್ಟಿದೆ? Learned Council, Learned DJ submits that the Commissioner of Collegiate Education has been posted for election duty and hence was unable to be present today. Relist on so and so on which date the Commissioner should be personally present. ಇರ್ಲಿ, ಅದೇನೋ ಒಂದು ತೀರ್ಮಾನ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ತೀರ್ಮಾನ ಮಾಡಲ್ಲ ಅವರು. ಏನ್ ತೀರ್ಮಾನ ಮಾಡ್ತಾರೆ? ಅಲ್ಲ, ಅವ್ರ ಕನ್ಸೆಂಟ್ ಕೊಟ್ರೆ ಇನ್ನ ಏನಾಯ್ತು? ನಿಮ್ಮ ಹತ್ರ 10 ರೂಪಾಯಿ ಇದ್ದು 2 ರೂಪಾಯಿ ತೊಗೊಂಡ್ರೆ 2 ರೂಪಾಯಿ ಇಟ್ಕೊಂಡು 8 ರೂಪಾಯಿ ಕೊಡೋದು ಒಂಥರ. ಇಲ್ಲ, ನಾನು 10 ರೂಪಾಯಿ ಕೊಡಲ್ಲ, ನಿಮ್ 2 ರೂಪಾಯಿ ಕೊಡೋವರೆಗೂ ಅಂತಂದ್ರೆ ಏನ್ ಅರ್ಥ ಹಂಗಂದ್ರೆ? ಅಲ್ಲ, ಇಷ್ಟ ದಿನ ಇಟ್ಕೊಂಡ್ರಲ್ಲ, ಅದ್ಮೇಲೆ ಇಂಟ್ರೆಸ್ಟ್ ಹಾಕ್ಬೇಕಲ್ಲ ನಾನೀಗ. ಅಲ್ಲ, ನಿಮ್ದೇನ್ 2 ರೂಪಾಯಿ ಇಟ್ಕೊಂಡು ನಿಮ್ಗೆ 8 ಕೊಟ್ಬಿಡ್ಬೇಕಿತ್ತು. ನೀವು 10 ರೂಪಾಯಿ ಪೂರ್ತಿ ಇಟ್ಕೊಂಡು ಅವ್ರಿಗೆ ಇಫ್ ಯು ಡಿಪ್ರೈಮ್ ಆಫ್ ರಿಟೈರ್ಮೆಂಟ್ ಬೆನಿಫಿಟ್ಸ್ ಬರ್ಲಿ ಅವತ್ತು.
Shri Ranganath Joyce.
This is a matter where your Lordship almost heard the matter, where the revision of pay scale on par with the state government has not taken place, my lord. Therefore, your Lordship wanted to know which are the pay scales available from the relevant point of time.
Time ಬೇಕಂತೆ ಅವ್ರಿಗೆ.
Document. Allah, it's simple case that they have not revised the pay scale from 2006. They are contending that.
ರಾಜೇಂದ್ರ ಕುಮಾರ್ ಮನೇಲಿ ಮದ್ವೆ ಇದೆ ಸ್ವಲ್ಪ ಒಂದ್ ವಾರ
ಅದಕ್ಕೆ ಅಬ್ಜೆಕ್ಷನ್. ಶಾರ್ಟ್ ಡೇಟ್ ಮೇ ಬಿ ಗಿವನ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್
ಡೇಟ್ ಕೊಡ್ತಾರ ಅವ್ರು.
December 13th.
You succeeded in seeing that the benefit is gone.
Now, they are putting words from the book. And my understand the legal of the. How you can take it. Where is the person that
ನನ್ ಮೇಲೆ ಹಾಕ್ಬಿಡ್ರಿ.
but this is, you know, that I can argue on the ground that we are entitled. There is the Supreme Court. But since your lordship is indicated the principle of fairness, this is not the way, madam. Court for regulate ಮಾಡಿ withdraw ಮಾಡಿ ಅದಕ್ಕೋಸ್ಕರ ಮಾಡ್ತೀನಿ ಅಂತ. And the opinion of both the lawyer. They can't defend this opinion. Opinion ಮಾತ್ರ ಅಲ್ಲ, government ಅವರು approve ಮಾಡಿಲ್ಲ ಅಂತ ಬರ್ತಿದ್ದಾರೆ. Board has already passed the resolution regulating all 107.
I did not say either withdraw the order. I said so long as the order was there, I am bound to follow that order.
But this is ridiculous. There is no ಎರಡನೇ page ಇದೆ. My land that all the officers, there are different discussion, what is the information, where is the problem, currently implemented this country, and giving the benefit of other.
16 ಜನಕ್ಕೆ ಕೊಟ್ಟಿದ್ರಲ್ವಾ ನೀವು? 16 ಜನಕ್ಕೆ ಕೊಟ್ಟಿದ್ರಲ್ವಾ ನೀವು? 9 ಜನ ಮಾತ್ರ ಇದೆ ಇಲ್ಲಿ. ಮತ್ತೆ ಉಳ್ಕೊಳುತ್ತಲ್ಲ, ಅವ್ರ ಬೆನಿಫಿಟ್ ಉಳ್ಕೊಳುತ್ತಲ್ಲ.
On the afternoon, we continued as a daily wages employees under the Karnataka daily wages.
No, but what if they have retired and given them pension? The other retire ಆದವರು ಕೊಟ್ಟಿದ್ರೆ ನೀವು?
ಇದು 9 ಜನ ಮಾಡಿದ್ದಾರೆ, ಮತ್ತೆ 16 ಜನದಲ್ಲಿ ಈ ಗೋಸ್ಕರ ಹೇಳಿಸಿ 21 crore 22 7 crore 18. There are 3 orders.
In 3 orders. Altogether 16 or 17 people were regularized. You have chosen to withdraw 1:9. ಅವ್ರಿಗೆ ಪೆನ್ಷನ್ ಕೊಡ್ತಾ ಇರ್ತಾರೆ ತಾನೆ, ರೆಗ್ಯುಲರ್ ಆದ್ಮೇಲೆ ಕೊಡ್ಲೇಬೇಕಲ್ಲ ನೀವು ಅದೇ. Are you sure? But ಹಾಕೊಳ್ಳಿ next time. Argue on merits, Mr. Lakshmana, next time. I won't have granted you time. You said you are considering the entire matter, and I thought you will pass a positive word. I didn't allow you to have a meeting in order to withdraw the benefit. ನೀವು ನಾನು ಕೊಟ್ಟಿದ್ದ ಇಂಟೆನ್ಷನ್ ಇಂಡಿಕೇಶನ್ ಕನ್ಸಿಡರ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ, ಏನೋ ಡಿಸಿಷನ್ ತಗೊಳ್ತೀವಿ ಅಂತ.
ಇಲ್ಲ ಪರವಾಗಿಲ್ಲ ಅಂತ putting the words of the court. Legally, I am convinced that Umar Devi one time measure, it has to be compliant. And court passes the resolution, violence cannot give an opinion contrary to the court. Vice Chancellor cannot annul the court resolution.
Next week we'll hear it on merits. Monday ಬೇಡ, ಡೇಟ್ ಕೊಡ್ತಾರೆ ಅವರ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲೇ.
That this question is covered by these judgments. And the Supreme.
it's a memo. Petition business.
Bill number 15, latest part.
Where's Ullad? Gautam Dev.
Bill number 15.
Let him come. Yeah, has he filed objections? Release on.
Jawab Ranjit.
Despite of the contempt has been filed, but now they say that the regulation is not according to the only discussion is just say ASP regulation. Only issue.
You got time care, buddy. List.
Really, they are not submitted the bill. Now it's under progress. The matter is again.
UVC ತಾನೆ.
Submit ಮಾಡಿದ್ರು. University ಹೋಗ್ಬೇಕು ವಾಪಸ್. Should not continue with the because submit ಮಾಡಿಲ್ಲ. Now ಈಗ they are submitting.
ಎಷ್ಟು ದಿನ ಬೇಕು ನಿಮ್ಗೆ ಸಂಬಳ ಕೊಡಕ್ಕೆ?
ಅವರು submit ಮಾಡಿ ಅವ್ರು ಬೇಡ ಅಂತ ಹೇಳಿದ್ರು.
That is not correct either. Already submitted, then they have to submit their refuse to law. Possibly they submitted.
ಯಾರ್ ರೆಫ್ಯೂಸ್ ಮಾಡಿರೋದು?
ಪಾರ್ಟಿ ಮಾಡಿದ್ರೆ ಇವಾಗ ಒಳ್ಳೆ
ಇಲ್ಲ ನಿಮ್ಗೆ ಸಂಬಳ ಬೇಕು ತಾನೆ ನಿಮ್ಗೆ ಈಗ? ಅವ್ರು ಬಿಲ್ ಏನೋ ಸಬ್ಮಿಟ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಮಾಡಿ. ಯಾರು ನೀವು ಅಂದ್ರೆ ನೀವೆಲ್ಲ ಬಿಲ್ ಮಾಡ್ಬೇಕಿರೋದು, ಯೂನಿವರ್ಸಿಟಿ ಅವ್ರು ಮಾಡ್ಬೇಕಿರೋದು.
ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಸಬ್ಮಿಟ್.
Yes, I appear for the university, my lords.
Have you submitted the bills for the salary?
No, my lords, the bills have not been submitted, my lords.
Why?
My lords, the employment was for UVCE, my lords. And
Correct,
UVCE was paying these salaries, my lords.
Correct, but they were deputed from your university, isn't it?
Yeah, absolutely, yes, my lords. That's right, my lords.
Why don't you submit the bills? They're ready to pay the salaries.
Very well, my lords. I'll take instructions, my lords.
Relist on. ಯಾವತ್ತು?
Next week, my lords.
8.
Grateful, my lords.
Release date ಕೊಟ್ಟೆ. ಎಂಟ್ರಿ ಮಾಡಿ ಯಾರ ಮೇಲೆ ಆಪರೇಟ್ ಆಗುತ್ತೆ? ಏನ್ ಎಂಟ್ರಿ ಮಾಡೋ ಕೇಳೋದು ಅವರು? ನಾಟ್ ಟು ರಿಲೀವ್ ದ ಪಿಟಿಷನ್ಸ್ ಅಂತ ತಾನೆ? ರಿಲೀವ್ ಮಾಡ್ತೀರಾ?
APSC has final list has been released on 7/8/2020. Even the additional list is also being published in the 31/8/2020.
Now they are working there. ಅವ್ರು ಕೆಲಸ ಮಾಡ್ತಿದಾರೆ ಇಲ್ವೋ ಈಗ? ಇಲ್ಲ ನೀವು ಅಷ್ಟೆಲ್ಲ ಅವ್ರನ್ನೇ ರಿಲೀವ್ ಮಾಡ್ಬಿಟ್ರೆ ಅಂತ ಅಷ್ಟೇ. ದಟ್ ಇಸ್ ಶ್ಯೂರ್ ರಿಲಿಸ್ಟ್ ಬಿಡಿ. ಅವ್ರದ್ ಮೇಲೆ ತಾನೇ ಎಂಟ್ರಿ ಮಾಡ್ರು, ನಿಮ್ ಮೇಲೆ ಇವಾಗ ತಲೆ ಕೆಡ್ಸ್ಕೊಳ್ತೀವಿ. ಅವ್ರ ಮೇಲೆ ತಾನೇ ಎಂಟ್ರಿ ಮಾಡ್ರು ಕೊಡೋದು. Mandamus. Who's for the respondent? Who's 2 and 3? You had entered appearance or who appears for Oriental Insurance here? This also will take notice for R2 and R3.
Next is
Latest.
Ramesh.
Appearing for the petitioner. The petitioner is made to work, my lord, in the department, my lord, as assistant professor. Head of the department makes a recommendation to continue the service. The matter is pending, my lord, before the registrar, my lord, before the vice chancellor. No action is taken, my lord. I have not been paid salary, my lord, from April.
Vice Minister.
Next year, A may kindly be seen.
ಇವ್ರ ಗತಿ ಏನ ಇವಾಗ? ನಾವು ಈಸ್ ನೈದರ್ ಹಿಯರ್ ನಾರ್ ದೇರ್. Now the prayer is to consider the representation. Will you consider and pass orders? Shall I direct them to consider your representation and pass an order?
Yes, my lord. Let them also pay salary, my lord, for the work done.
The prayer in this petition is to issue a direction to the third respondent to consider the representation stated 6/3/23, 6/4/23, 19/8/23 and 16/20/23, and also extend the tenure of the petitioner. A further prayer is made that a direction issued to the third respondent to pay the arrears from 9th of April 2023. Prayers are also made to provide and fix the salary of the petitioner on par with the UGC scale employee and for a direction to regularize the service and absorb the petitioner. Next. From reading of annexure A, it appears that the petitioner has been working as an assistant professor on a temporary basis in the Department of Studies in Public Administration for the past 7 years. It is also forthcoming from this annexure that the chairman of the Department of Studies in Public Administration is of the view that the service of the petitioner was essential, and he therefore recommended that his tenure be extended. In view of this letter of the chairman of the Department of Studies in Public Administration, it would be appropriate to direct the third respondent to consider the said recommendation along with the other recommendations and the representation of the petitioner and pass an appropriate order within a period of 2 months from the date of receipt of a copy of this order. So if the petitioner has worked as an assistant professor temporarily, it is obvious that he would also be entitled to the salary for the period during which he worked according to the terms of his appointment. The third respondent shall also take into consideration this aspect and pass necessary orders regarding the arrears of payment. Writ petitions accordingly allowed to the extension of whatever is the terms of your appointment. I can't change it now. Okay. ನೀವೆಲ್ಲರಿಗೂ ತೊಗೊಳ್ತಿರಲ್ಲ notice? Since Ch16 has accepted notice for R1 to R4, there will be no need to pay process fee. Relist on office objection complaint with the office objections. Relist. What is annexure L? You're challenging annexure L. ನೀವು ಗವರ್ಮೆಂಟ್ ಸರ್ವೆಂಟ್ ಅಲ್ವಾ? No, should you not go to the KAT? Can I entertain a writ petition? The Department of Health and Family Welfare ತಾನೆ ಅದು. Department of Health and Family Welfare ತಾನೆ ಅದು. ಇಲ್ಲ ಅದು ಡೈರೆಕ್ಟರ್ ಆಫ್ ಮೆಡಿಕಲ್ ಎಜುಕೇಶನ್ ಆಗುತ್ತಲ್ಲ, ನೀವು ಅಲ್ಲೇ ಹೋಗ್ಬೇಕಲ್ವಾ? This is not a pass by the government. What is your status? ನೋಡಿದ್ದೀರಾ? No, where is your contractual appointment? Terms of your contractual appointment? Next year? Get instructions. Release on. G accepts notice for. ಸಂಜೆಗೆ ನೀವು ಅಪೇರ್ ಆಗ್ತಿರಲ್ವಾ? ಅಲ್ಲ ಸಾರಿ, ಅಟಲ್ ಬಿಹಾರಿ ವಾಜಪೇಯಿ ಅಪೇರ್ ಆಗ್ತಿರಲ್ವಾ ನೀವು? But the order is passed by you. Then AG accepts notice for R1 and R2. C. Nagashri accepts notice for R3. Notice to R4 is deferred for the present. Relist on. It is passed on 7/11. So let us see. For R3 na? In matter na? Release on. Give another copy.
I passed an order, and the second and third business. Page number 40 of the.
ಯಾವ 21/11 ಹಾಕಿರೋದಾ?
Yes. Based on this order of the rate of interest.
There is some other page number 14. It is open for the appellant. Appellants to make a representation. Page number 14.
Yes, based on this order of the rate of interest, again, other petitions are disposed. Connected petition.
Now come to page 14.
14. Can you see page number 13? The no interest is called for with the include order and accordingly the appeal is dismissed. The interim order is for operating in the disposal of the petition by the law single state will continue to operate for a period of 6 months from the and date on which this order is just passed on the respect of the court. It is open for the applicant to make a representation to the second and third respondents for applicant by
ಇದನ್ನು ಕನ್ಸಿಡರ್ ಮಾಡಕ್ಕಾಗಲ್ವಾ?
No, my lord, these are the also
No, but this is the
yes.
if the revision bench has said in this case,
Yes.
they'll have the same liberty.
Yes, other section. Saving only. The same, no,
Page number?
page number 40.
Yes.
Hence the challenge, paradigm, hence the challenge made to the notification dated 21. As per the deadline pertaining to the response and recognition of the petitioners are rejected. However, the response are made with the.
Madam, this order was passed in February 2020.
Yes,
Division bench passed the order in March 2020.
yes.
Same liberty I'll give, that is all. I simply say the petition is disposed of in terms of the order of the division bench.
That, was the, at the time of the period. Has been given, my lord. Now there is no such situation as, arisen, my lord.
They have continued in service from then.
Indeed, by the same order.
Same thing will continue till you consider their case, that is all. ಅವ್ರಿಗೇನು ಕನ್ಸಿಡರ್ ಮಾಡಲಿಲ್ಲ ಹಂಗಾರೆ we have not considered their case at all.
No, my lord, in view of the executed or continued, they have not challenged, they have provisional list, my lord. They have challenged only, the provisional list.
Correct, but ಈ division bench ruling ಆದ್ಮೇಲೆ they were permit to make a representation to absorb them in regular service and
The selection process has been completed.
ಈ portion of the order ಏನ್ ಮಾಡಿದೆ second portion
I love you.
did you or did you not consider? ಅದೇ ಮಾಡಲ್ಲ ಅಂತಿಲ್ಲ ನೀವು. This court did not disturb the final, the select list. This court said consider their case. Will you consider or not consider? The issues raised in this writ petition are admittedly covered by the decision rendered by the division bench in writ petition number 219/2020, which was decided on 12th of March 2020. In view of the above, this writ petition is disposed of in the same terms. As ordered by the division bench, it will be open for the petitioners to make a representation to the respondents for absorbing them in regular service, and the petitioners can also rely upon the power of relaxation conferred on the board under the regulations. The petitioners are also at liberty to rely upon any decision which is stated to have been taken by the government according to them to absorb such category of employees. The representation made with the petitioner shall be decided within a month from the date on which a copy of this order is received by the respondents. The interim order idea name, the interim order granted in this writ petition would enable to the benefit of the petitioners for a period of 6 months from the date of receipt of a copy of this order to the respondents. In a Delhi High Court, and Delhi High Court, what happened to Delhi High Court?
I'm not challenging. Guys, they're challenging pending. And the exterior itself challenging other.
Tuesday, Wednesday. I'll have this on Tuesday. Today I have too much of matters. Take it up. Tuesday I'll take it up.
As well as not the video.
1 minute.
Sir, Kumar.
11th.
Number 29.
The national pension scheme pattern, asking about that is a suggestion. Because it appears only out of 1,200 odd employees in that particular batch, only 372 totally reported. Whereas for everybody else, we have removed that 2% balance, whatever. We have given them 48 equal installments in which we recovered the money from them. And insofar as the benefit to the employees are concerned, earlier KPC should be only 10%. Now, since 2012, KPC is now contributing 14%. Employee puts in 10%, I put in 14%. So, therefore, it is a more beneficial scheme. In such situation, there's a constitutional judgment of the Supreme Court, where they have said that where pension scheme is beneficial, it can apply retrospectively. Their concern was that how can it apply retrospectively? But then,
Who was responsible for the delay in implementing that NPS?
What happened is that 2006 onwards, it's applicable to all the employees of the state government. We made it applicable from 2012 onwards. We made it applicable from 2012 onwards by a notification in 2015. Now, what the government did was, government said, no, for all the state employees across the state of Karnataka, we are doing it from 2006. You can't have an exception. So they issued an endorsement saying, no, we have to do it from 2006. So because of that, we had to retrospectively come back. So not only us, KPPC, ESCOMs, everybody 2006. So therefore, there's no anomaly or no hardship cost to any person. Because whatever money is being deducted, that money is going to their own pension fund. It's not going to everybody else. Along with the accrued interest. Whatever is the accrued interest, that also is good.
No, but you're forcing them to bear this sudden recovery for no fault of theirs.
Just one. There are two parts of this. One part is that from say 2019 or 2019 onwards till 2010, there are a few employees of 2014. Insofar as the 2010 employees are concerned, 2% of their basic is going to be deducted. That is going to be deducted and then put into the fund. It is not going to come into my pocket. It's going to go. That is one part. Second part is during the pendency of this expedition, we are stopped from deducting that money. But on the other hand, we are still contributing 14% because I am statutorily mandated. It's not my pension scheme. It is mandated by central government, adopted by all state governments, and everybody is doing it at 14%. So now I have already deposited 14% for all of these employees when they retire. So the difficulty is what they are saying about retrospectivity, the 2% amount, but it will not come out substantial. It will not be such a.
Therefore, I suggested that you bear the burden and close the matter. Why do you want to? You are giving it.
The difficulty is that there are 332 for my house. There are 1,200 who belong in the same way. Leaving aside them, there are subsequent others. Totally more than 6,000 employees. 2%. But I cannot bear it because I am a regulated entity. The difficulty that I have is that I am a regulated entity. Karnataka Electricity Regulatory Commission looks into my pension schemes and fixes the tariff for the electricity that I generate. There is a factor called as employee cost. Then employee cost is factored on the basis of.
On the next revision, they will take into consideration this.
Everybody else is like that.
No, therefore, if you voluntarily say for everybody, I will bear that cost of 2%.
And it won't be that, but they are not based on record before my lords. As to
how exactly they are aggrieved by the NPS. I want to see the pleadings what they have filed, and I find a detailed counter statement where I explained as to how it is beneficial. When it is beneficial in that manner, there is a judgment of the Honorable Supreme Court itself in the Ex-Servicemen Association case, where they said that it is beneficial, it can be applied across. In any event, pension cannot be applied retrospectively in India as against a retired person. But for every other person, it's an incident of service. So therefore, to that extent, can apply retrospectively. Insofar as 6 years.
Up to 2006, you had an earlier system where how much would you contribute?
I would contribute 10%.
And they would contribute
8%.
8%.
8%.
So that is now changed to 14 and 10.
Yes.
So the 6% increase, 4 of which you will bear.
Yes.
And they will bear 2%
Yes.
extra.
Yes.
Over and above that.
Yes.
I think you can bear that 2% from that particular date for all your employees.
The difficulty is that if the laws passing the order here for only these are.
No. If I'm going to pass an order, it's going to be universal.
No, the difficulty in the laws pass an order, then KPTC has already they have done it, they have deducted it.
No. What I don't understand is if you drag your feet in applying this NPS scheme, you are aware of this new scheme. No. If you do not take a decision immediately, and if you allow the matter to linger on, according to your interpretation.
This one, on 21/6/2012, we have adopted NPS for.
Why did you wait for 6 years?
It was not applicable to us until state government.
That was your understanding, right?
No, state government adopted it on 19/1/2010. Our state government adopted NPS
with effect from 2006.
No. Yes, it is with effect from. They adopted it.
Then why did you again wait for 2 years?
The problem is that decision was not taken. What? I don't know. The difficulty is that the laws were to pass an order. Every single state government employee for whom it has been made applicable retrospect, it will have ramifications. Everybody will then. State sector will then massively suffer because already amounts have been deducted. Only in so far as for these 372 my lords can't carve out this application. My lords have to make it a broad base. When my lords are looking to make it a broad base thing for each person. KPTC, Westcom, Chescom, every other state and state PSU who all made it applicable from 2012 onwards, all of us made it applicable from 2006 because the direction came around 2010. Every single person, not only that, every single state government employee, everybody will then come before my lords, including this judgment, and it will have a large scale application. On the other hand, my lords is 2%. It's not going anywhere. It is their own money. It is going to their own pensions. 48 installments is what my instructions are, which we have given to everybody else, and nobody has protested except this case. 200 in my friend's case, and then there are a few other.
But I think there's as far as the judicial department also, there's one case. Our judicial department also has one particular case like this, where they applied this from a later date. So some of the employees are challenging it, saying that you are responsible for the delay, not us. So therefore, you should bear the burden.
Well, it's over a judicial employee. Judicial officers are concerned. They are governed by the Supreme Court statute.
And this employees, they're governed by the same 2006 scheme.
A lot have to take all the matters together and then take the strict view on that because it has a very large scale ramification. This case, my lords passed an order. Tomorrow, KPTC people come. Thereafter, my lords ESCOM will come.
You were supposed to pay this money to that provided pension fund, right? When did you exactly appoint that pension fund, and when did you make that payment?
15 hours. Then my lords, actually, lords, PFRD, so far as PFRD is concerned, pension P1 2019 is when our scheme was approved and they adopted it. P1 20. That is in so far as we are. So, the difficulty that I have is that I'm not looking at it from the perspective that okay, these people are ending up paying 2% of their money over a period of time. Whereas that there has been supplement pay. Actually speaking, there has been every 4 years there's a pay revision. So, what we are going to deduct 2% will be of the basic of that pay. So, my lords take into account the pay revision also. We will not have a financial. My lords wants a bird's eye view of the financial impact. I try to arrange for a document which will give my lords the bird's eye view of the financial impact for these employees. Then my lords may, I think
If I accept your argument, it is only 2%, not a very big sum. That should not be a very big sum for you also.
The difficulty was 372 people.
No, for all your employees, this was your own making. See, when it pinches you, then you cry. When it pinches others, you're saying, no, it's for your own good. So endure the pain.
Cannot now create a class of people for the 372 because the rest of their colleagues who are the same batch who have been recruited in 2010, it's couple 1,200, roughly 1,172. They are all adopted this. So for the 372, my lords, I have to carve out an exception. That's one problem.
Suppose I were to say that because they have access to that, they cannot. Why not? If they may accept it, maybe because they feel it's more beneficial.
They are saying
If
the difficulty is that their relief is that they are saying they want the old pensions, which is actually not beneficial to them because the old pensions came only here to them or not. Well, it's beneficial in the matter. I just point out a judgment of the Honorable Supreme Court on just that.
what is the prayer in this petition? What is the prayer in the petition?
They are entitled to the world pension scheme. As for the recruitment notification, it is not, they have assured that these persons, these petitioners are also entitled to the world pension. At January 2010, the recruitment notification itself was at page 99, next year P.
What is the next year P?
Next year P words is page 142. 7/3/2020 words, the reform of proceeded to implement the NPS with retrospective with effect from 1/1/2000. Recruitment notification by candidates is not at page 99. Relevant is at page 102. Hundred and one. Clause 4. Where new pension scheme has been implemented. Notification itself says what the notification of what page 99. But the recruitment notification itself says they are entitled for work pension.
Where is the original decision of the 2010 of the government?
Page 99. Sorry. Page 94. Next will be.
Next year C and D are the same. The next year C is that 31st of March 2006.
This is on 91/2000.
Which is this 2015 government order that they refer to in this annexure?
Page 127.
27.
Yes, yes.
But these government orders are silent as to what should happen to this period from 2006 to 2015.
They say, no, subsequently there's one more circular, which is that 29. Procedure will be followed.
Then again, that's not, they don't talk about the period between 2006 to 2015.
Right, because the architectural scheme is such that whatever money is there, currently for these employees, we are, their 8% is being deposited in the GPF. We are giving them between, there were 1.9% to 9.6% interest or 8.7%. So interest along with their accumulated corpus is there. So what is now going to happen? The entire interest along with accumulated corpus will get attached. Now there are two options available to any employer.
No, it was according to 8% for them.
Yes.
It becomes 10%.
Yes.
You have been deducting 8% and that is earning an interest,
Yes.
right? Suppose you were to invest that 2% extra, how much would the cost be?
That for the entire organization. For the entire.
Because see, they have not challenged this new pension scheme. They have accepted this. This problem arose because of decision of the government to implement from 2015. If the government were to say from 2006, somebody has to bear the cost. Why should you push it on the employee?
They are not saying that they want new pension scheme. They are saying we want only old pension scheme.
There is no prayer in the petition saying that the new pension scheme should not be accepted.
No, so what that is the thing, how it is worded is, they are saying that it is not applicable to us because we were recruited in 2010. So because we are recruited in 2000.
But I don't see in the prayer as to such a declaration that is being sought that they have to apply the old pension scheme and not the new pension scheme. I don't think it lies in their mouth to say that they will not be applicable. They will not be eligible to avoid the NPS.
Prayer to members, prayer to. But I was that the requisition 10/8/57/2020.
10857.
Yes. Prayer to members that basically.
Yes.
Prayer to.
If you ask for this, it'll stand reduced. But how can you get over this 2015 order?
Whatever we brought the these persons will be entitled.
2015 circular. How can you avoid it? You're not even challenging it.
But I have questioned.
This circular is applicable. This circular is applicable across the board. There are no exceptions granted. Only in respect of aided institutions, they have an option to either accept it or to reject it. That is, they don't want pension. For those people, only it will apply. How can you escape the liability of this new pension scheme? I was only concentrating on this difference. But how can you disown this scheme?
These persons were from.
Then at the time when you retire, you will come back and say, no, that was more beneficial. Give that to me now.
Cannot come back and say that, Lord, once they come into the court and.
But if the government had taken it, then you should challenge this 2015 order. Annexure J.
Yeah, one question.
Then that is a basis for them to adopt this new NPS. I don't, like he said, it's better for you to go into that NPS instead of this old pension scheme. They will also contribute more than earlier. But where did you get 14%? It only says 10%. But normally it is 10 and 10. You contribute 10%, they contribute 10%. If you can increase it to 14%, you can also increase it to 15% and ask them to bear the other 1% for this particular period.
I have a suggestion subject to what his concern is it should not come out of this money today because it will cause an immediate financial hardship. There is accrued interest. Whatever money as 8% is given, we have been paying interest on that. Whatever 1 month, 8% प्रति दिन में कटा रहता है. You got 20% and 100 रुपए कटा है. 100 रुपए we are paying 9%. Every month 100 रुपए 9% interest comes up to a decent amount of money over a period of 5 years.
Why are you paying interest? The fund will pay that interest. That provident fund will pay that interest. Where will you?
We are the trustees of the fund. We are managing.
That is invested somewhere else. Therefore, you are not giving it from your pocket.
I didn't mean to say this. My apologies. What I'm saying is that there is some interest accrued. If there is concern that that 2% amount is going to be a substantial amount of money, I don't want to pay it today. Then they can give a letter to the corporation. Adjust it from the some of the employees are done. Some employees.
No, if you adjust it from interest, again there will be a loss to them.
There is a proportionate reduction.
What I am saying is you have agreed for 14% voluntarily on negotiation. Make it 15%, let them pay 1%. As it is, you have jumped 4%. There is no.
There's over a period of time that's extended to all employees. Now the difficulty is this: if I say I will pay 2% of this salary, 2006 employees will come. They will say pay.
You undertook 4% extra.
That's for all, not for him.
So therefore, 1 more % extra to all the employees should not really matter.
It will matter. If my lord wants the number, because my lord, I think the problem is that I'm not able to show my lord is the hard numbers. To get the hard numbers. So because it's a people, one person.
NPS need challenge Mandela. Therefore, I can't go into that question.
But we have trained your.
How can you do that in the light of the government circular? It's across the board. This is the policy. No, they are not to be blamed. They are not to be blamed. 2015 government said it will apply to everybody else. Therefore, that was the date. Now thereafter, government says no, issue from 2006. They are not really to be blamed. It was not their unilateral action. They applied this new NPS only because of this 21/2/2015 circular. There's no challenge to them. I'm only worried about this 2% for this particular year. They were not to be blamed. It is not like as if they said, I will not pay. You were collecting 8%, they were happy with 8%. Then suddenly when you jump it to 10%.
But my lord asked me a specific fact of this case that 2% impact is there. Is there a judgment? I'm not able to find. But in
insofar as the pension scheme is concerned, madam, whenever we revise the pension scheme, certain people come and challenge it, saying you are applying it retrospectively. You can only, suppose if I start a new pension scheme, it can only apply to new employees. That is the contention. Contention of law is that.
So long as the 2006 circular stands, and if they're appointed after 2006, without there being a challenge to it, they'll have to
Yes.
follow it.
So that matters. Similar situation, the Supreme Court has said that it can be retrospective. That matters are produced.
ಆ 2% ಮೇಲೆ ಏನಾರು ಇನ್ನ ಮಾಡಕ್ಕಾಗತ್ತೆ ನಮ್ಗೆ ಅದ್ಬಿಟ್ಟು I don't think I'll be old pension scheme. I don't think there can be a separate island created for only 372 employees when across the state, across the country, 2006 circular is being applied, and for central government is from 2004. Find out if there can be some kind of negotiation for that. No. Since you are asking for 14, I'll ask them to bear 1%. You bear 1%.
That enhancement not happening. It's a labor negotiation. There are more than 20,000.
If you're going to give something extra to the labor, nobody will say no. If you want to take away something from them, then they'll say.
Entire state is in financial risk.
ಯಾವ್ದಾದ್ರು ಹಾಕೊಡಿ. In order to continue to. In matter, no?
Period from 2010 to 14, they were rightly maintained in the not from 14 to 19. And in 19 was suddenly tankers below the customs who have been promoted in a lot in excess of the quota in a lot meant for them.
Is a batch matter the boroke.
The last time we lost third mean not they took time a lot twice.
Who's to file the objections? Yaar sign madad yaar. I'll give you 1 week's time. If objection not filed, commissioner shall be present before the court and the market. They'll. No, if that order is there, then they will act promptly. As a last chance, time is granted till so and so to file statement of objections. If statement of objections are not filed by then, the special commissioner administration shall be personally present before this court. Relist on. Post along with. Not one day, it will come up someday. Relist on.
Yes,
Promotion to stand extended.
Serial number 34, Your Lordship.
GVRಗೆ ಮಾಡಿದಾರ in 8054 they have filed. Ready? You are ready? Are you ready? What is the challenge you said? You are appearing in, you are working in Rajiv Gandhi University Health Sciences. As what? You are not given any weightage here? Weightage and ಕೊಟ್ಟಿಲ್ವಾ? But there can't be a stay of the recruitment, isn't it? Which is your post? Because the notification is in relation to ಹಿರಿಯ ಸಹಾಯಕ group C. ಎಲ್ಲರೂ ರಾಜೀವ್ ಗಾಂಧಿನ, all of them? How many petitioners? Bari your challenge only the notification. Where is the rejection of your claim for regularization? You not brought 2012 Act ತರ್ಲಿಲ್ಲ ಅವ್ರನ್ನ. Which order?
Yes, I have not on the record, each of the cases, all matters related to partnership. Each case will have taken on notice. So some of the questions, there are questions from your common questions.
But if you don't bring them within the 2012 Act, regularization is one thing.
Yes.
But shouldn't they be brought under the 2012 Act if they're working from 88, 89? At least they'll get the minimum time scale of pay.
The regularization, that pattern will happen.
ಅದ್ರಲ್ಲಿ ಬರ್ಬೋದಲ್ವ ಅಂದ್ರೆ 2012 Act ಯಾಕೆ ಅಪ್ಲೈ ಮಾಡಲ್ಲ ಇದಕ್ಕೆ? I can't stay the recruitment notification because next week ಹೇಳಿ ಒಂದು list on. You still take time. March notification, still take time. Nothing will happen in the government within a week or two. Let us see next week. I can't stay the recruit notification. All that I can say is subject to the result. That not any to your benefit. Okay, next week, no. 2012 Act ತರಕಾಗತ್ತೆ ನೋಡಿ ರವೀಂದ್ರನಾಥ್. 2012 Act ತರಕಾಗತ್ತೆ ನೋಡಿ ಅವರು. 34.
Before I appear for the respondents, my lord,
Yes.
my statement of objection is I'll be filing it in the coming week. This may be heard next week finally, my lord.
What is your punishment imposed?
Termination. This is pertaining to fake smart card case, my lord.
Najunde. Next week, Akir. Realist.
Please, my lord, I will file this.
But the input order suspensions are passed on 7/6/2023. Even till date, there are no charge paper, not charging has been filed against him. The Honorable Supreme Court decision in Ajay Kumar Chaudhary's case, Melod has cut out the relevant portion. If the charge memo is not been issued within the 3 months, the input order suspension will have to go, Melod. There are the
Who suspended you?
Well, it is the Deputy Commissioner Melod who has suspended me.
The
rules. The Deputy Commissioner does not have the power, because under Rule 10 of the KCSPCA, it has to be done by the appointing authority.
6 months ಆಯ್ತಲ್ಲ. 7th of June. ನಾನು 8 ತಗೊಳ್ತೀನಿ, 8 ಹಂಗಾರೆ ವಾಶ್ ಮಾಡ್ತೀನಿ. 8.
Be that informed in the
Date ಮಾಡಿದ್ರೆ ಅಂತ.
It was 36, Vidya Ganesh Rao.
Original tension is not there.
ಯಾವತ್ತು ಹಾಕೊಳ್ಳಿ ನಡೀತಿ ಎಂಕ್ವೈರಿ ನಡೀತಿದ್ಯಾ?
On the day of the inquiry and Vijayawada, he got that uneasiness and he was admitted to hospital there is the nation cardiac center. So he would be temporary. BP was 190 and now he is under the treatment in his place.
ಮಾಡಲ್ಲ ಹಂಗಾರೆ ಎಂಕ್ವೈರಿ.
3 months time ಇದೆ. 3 months on ಮಾಡ್ತೀನಿ. I was told now yesterday he has not got check up and he has been admitted.
CTP Matana submits that
There are medical certificates.
the bank would be requesting the pension benefits.
But now they're affected.
These are medical records are there.
In the course of the day. Is permitted to relist on.
Start.
Yes, recorded.
Yeah. Relating to the key answer. Key answers that relate whether the final key answer could have been unilaterally replied. So far as assistant engineer just report has allowed the information.
Just to verify that is there any major thing that takes place with respect to configuration of this amount of the additional.
There is a discussion of 52%, 32% for in the second year. That really have made it correct.
Yeah.
No, but if you take your own time to come to the court.
Can we see this? What happens? I understand where you are.
The lordship is pleased to take note the list of 3rd January 2023. First, the lordship is pleased to take to the list here, 27th December, the original list. And then 4th February.
Actually, the petitioners.
Alexander.
And they come within both.
I to support that, my stand, my lord. If your lordship is pleased to take the list announced by AEA with respect to 27th December, answer number 77, first list, first page. First page is the 27th December 2022. So 77th question, 2 ಅಂತ ಇತ್ತು. ಮತ್ತೆ 4th February 77 question next page 2 and 3 ಅಂತ ಬಂತು.
Second page.
77 right hand column. 2 and 3. Who have answered 2, who have answered it as 3, we have considered both. A has considered both. So Agagi, if your lordship is pleased to appreciate the next list that which I have just produced here. January 3rd January list serial number 607 is one Sunil L. one of the petitioners.
Page number. It's not 7.
07.
Raksha. Yeah, page.
In my interpretation, your lordship will find it at page 107.
I'll stick with 1 because I can't keep going from this to that.
Oh, that's correct.
6 start.
Then you see-
6 not 7. Sunil Lemma.
Sunil.
Is there in the finalist also in this February 23? All three petitions.
Both the list.
Then in what way are you aggrieved?
But my ranking is pushed down. If I'm assuming that if I'm 10, I'm pushed down to 25.
What was the ranking in this
That is something that.
4th February 23 early?
That was ranking is changed. Because 32 candidates coming. 32 candidates coming. But now, a respectful subdivision is for all the candidates who are in the first list as well as the second list, DV is being conducted. Document verification is being conducted. So if they are eligible as per the DV list and the HK, non-HK, both are considered, if they come, they will definitely stay. So their contention before this honorable court is very clear is that the first list should be considered, not the second list. If first list is also considered, same. Second list is also considered, same. Now my respectful submission, Your Honor, in the AE list, your lordship had directed us to complete the process before 13th December and submit the list. The honorable court submitting the complaints. In that, as examinations were conducted together, even the complete inquiry, the verification of documents, everything is complete, even in this, because it was a segmented examination. Now, if there is any order being passed by this honorable court, now we'll have to redo the complete process wherein all were considered together. Now, if there is an answer, no, the answer to this honorable court. There were exams conducted for junior assistants on the same notification. Junior engineer civil, assistant engineer civil. Again, there were another fresh batch of deputations who have not even tested the honorable court now. Now, almost in this JE, 1,500 document verifications is completed. With respect to both the lists, we have taken into consideration and document verifications.
Ritvesh, this list was published on 4th of February 2023.
So that takes into
I don't want to entertain a petition 8 months after the final.
Let's 9 months. Please consider this. I'm only just placing it for your lordship's consideration. When the judgment of assistant engineers came out, that is on August 2023. Nothing prevented APTC to go ahead and apply the same thing to the rest of them. And that is what your lordship also even recently held. But for one set of employees, there cannot be a different rule. And for the rest of them, it can't be. Insofar as KPTC exercises, then because your lordship insofar as KPTC.
Arvind Srivastava's case. That is on a declaration of law. This is on a different footing.
You are not saying that once you have published the final key answer, unilaterally you become.
I agree. But why should I entertain a petition instead of people who kept quiet for?
This is essentially what your lordship said. I quite agree with what your lordship is saying. But all of us who were writing essentially we are in the same thing as the assistant engineer or similarly situated persons. Today, the only reason why we are denied this.
Maybe you should have.
I quite see what your lordship is saying. But it was essentially the same thing that was challenged for your lordship. Other than the nomenclature of the post.
No, if you had joined in, then they would have done it. You waited for this, and only on the basis of this judgment, you are trying to stake a claim, isn't it? That is also frowned down upon in the Srivastava's case.
This is a case where I'm only seeking the benefit of the very same judgment. I'm only saying the ratio there completely applies to me, other than nomenclature. If it was a case,
Bide, ಇನ್ನೊಂದು case ನೋಡೋಣ.
there are the other two examination candidates are also now on the bench later, taking into view this reputation thing, because that was what was given to me as an information.
It's
There was
obvious.
again consent test. ನಾನು ಇದನ್ನ ಅಪ್ರಿಶಿಯೇಟ್ ಮಾಡಿದ್ರೆ ನೆಕ್ಸ್ಟ್ ಇನ್ನೊಂದು ಯಾರು ಎಲೆಕ್ಟ್ರಿಕಲ್ ಅವರು ಮತ್ತೆ ಎಲೆಕ್ಟ್ರಿಕಲ್ ಬರ್ಲಿ ಅದನ್ನು ನಾವು
No.
If the selection was complete, that would have been very as per the complex selection will be released. Selection is not yet prepared. Therefore, before rights are crystallized and before your lot.
Not after 9 months.
But even before rights in favor of anybody else, adversarial rights are created.
You know, this is going to be another jinxed selection process on the concert. You will ensure that no selection process.
By separate judgment tribunal upwards 371 day circular. In another judgment day before yesterday, that entire circular is passed by the tribunal. Therefore, that selection now again. State government and each and every day we are facing from 2017 this was in 13. That incident has happened that and deputation has been made and media has now been aware of the decision that there are some 3 candidates who have died here. Now the question is that we are delaying the process. Nobody is understanding the legal procedure which is being taken place before your lordship is here.
That is the reason why I fixed it so that they won't drag the
media, position is very bad.
media ನಾವೇನು ಮಾಡಕ್ಕಾಗಲ್ಲ.
So I would request
dismiss it unless you withdraw it.
For the petitioner, please, my lord.
Date ಕೊಟ್ವಲ್ಲ ಅವ್ರಿಗೇನೋ ಟೈಮ್ ಬೇಕು 2 ವಾರ ಟೈಮ್ ಬೇಕು ಅಂತ ಅನ್ನೋದು ಇಂಟ್ರೆಸ್ಟ್ಮೆಂಟ್ ತಾನೇ ಇದೆ ಅಲ್ಲ ಇಂಟ್ರೆಸ್ಟ್ಮೆಂಟ್ ತಾನೇ ಇದೆ ಅವ್ರು ತಿರ್ಗಾ ಒಂದು ಟೈಮ್ ಕೇಳ್ತಾರೆ ಅವರು ತಿರ್ಗಾ ಅದೇ ಆಗತ್ತೆ
Just 1 week instruction.
Release on. Release. Released.
42.
Who's opposing you?
And she was terminated on 8th October 2022. But for some time, and the court posted question whether the inquiry was conducted, the inquiry was conducted, formal inquiry. I answered that there is no need to conduct formal inquiry. I observed that it is a serious imposition of punishment had by and condition is that The notice of termination may be considered as a basis. On that basis, we further initiate the proceedings for disciplinary inquiry. This point of time is over now. This point of time.
He's 59 years now.
She retired on
Retired agata.
31st. Notionally, she retired on 31st May 2022. So if they hadn't taken into consideration, 45 months services was left out. And she was earning 28,000 salary per month at that point. But by commission, we tried to have been prevail upon our there. 30% of 25% of the act in the
ಯಾವತ್ತು ಟರ್ಮಿನೇಷನ್ ಮಾಡೋದು ಆರ್ಡರ್?
The order of termination was on 8th October 2018.
They retired in 2022.
She retires on 2022, 21st May 2022. Her date of birth is 27 May 1962.
50% ಮಾಡಿ ಕ್ಲೋಸ್ ಮಾಡಕ್ಕೆ ಹೇಳಿ.
Common date will be given. And
Release on.
Another day.
Next year K na. ಒಂಬತ್ತು ಲಕ್ಷ ಸ್ಪೆಸಿಫೈ ಮಾಡಿದ್ರ ಕೋರ್ಟ್ ಅವರು ಪೇಜ್ ಅಲ್ಲ ವೇರ್ ಇಸ್ ದಿ ಆರ್ಡರ್ ಆಫ್ ದ ಕೋರ್ಟ್ ಟು ಪೇ 9 lakhs page 56 So 9 lakhs is fixed, you can't go beyond 9 lakhs. ಇಂಟ್ರೆಸ್ಟ್ 4% ಕೊಟ್ಟಿದ್ದೀರಾ? ಇಂಟ್ರೆಸ್ಟ್ ಸ್ಪೆಸಿಫೈ ಮಾಡಿರಲಿಲ್ಲ.
2005 ಇಂದ 10 ವರೆಗೂ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ 2023 ವರೆಗೆ ಕೇಸ್ ಹಾಕಬೇಕಾಗತ್ತ. And whether this can be gone into in the petition.
ಇಲ್ಲ 2010 ಇಂದ 2014 ಯಾವ ಡೇಟ್ ಎಷ್ಟು?
Date of stand. But assuming there is some.
9 lakhs ಆಯ್ತಲ್ಲ ಇಂಟ್ರೆಸ್ಟ್ ಅಷ್ಟೇ ಕೊಡ್ಬೇಕಿರೋದು ನೀವು. 4% ಕೊಟ್ಟಿದ್ದೀರಾ? 4 ಅಂತ ಎಲ್ಲಿ ಬರೆದಿದ್ದಾರೆ? ಎಲ್ಲಿ ಬರೆದಿದ್ದಾರೆ 4? Next year? Page 20 na. ನೀವು ಪ್ರೇಯರ್ ಏನು this petition?
Both are
Prayer B.
That is rejected. It's the section one that you are reading for. All these that are being manipulated for. Assuming that some time
2005 to 2010. ಅದೇನಕ್ಕೆ?
ಅದಕ್ಕೆ ಅವ್ರ next B was. Thank you.
ಬರೀ 10,000 ರೂಪಾಯಿ ಹೇಳಿದ ಅಷ್ಟೇ. ಆಯ್ತು. ಅಲ್ಲ ನೋಡಿ ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಓದಿ. ರಿಗಾರ್ಡಿಂಗ್ ಅರಿಯರ್ಸ್ ಆಫ್ ಸ್ಯಾಲರಿ. ಅಲ್ಲ ಅಲ್ಲ the calculation I don't seem to understand. There was an appeal that was pending with the tribunal. That appeal is disposed of in terms of the joint memo, whereby your arrears of salary was only rupees 10,000. Nothing more. ನೀವು ಅಲ್ಲಿ ರೆಪ್ರೆಸೆಂಟ್ ಕೊಟ್ಟಿದ್ದು ಏನಂತ ಇವಾಗ ಈ ಸಲ? Where is your letter 98/2019? Two 2005 to 2010 ಯಾರು? Where is the determination anywhere?
I think I have been asked to get.
ಇದೇನಂಗ ಮುಗಿಯಲ್ಲ ನಂಜರೆಡ್ಡಿ ಅವ್ರು ನೀವು ಫಸ್ಟ್ ಒಂದ್ಸಲ
The government is not. Government itself has not done.
how to apply, how to calculate. Calculation ಇರಬೇಕು ಯಾವ ತರ. ನಾನು ಉತ್ತರ ಕೊಟ್ಟಿದ್ದೀನಿ, ಯಾವ್ದು ಬರೋದಿಲ್ಲ. Assuming that the Lord is acted for company and acted play is not in order. Yes, or conceptual. Appeal ಆಗಲ್ಲ, because it's not place of calculation ಆಗುತ್ತೆ. Appeal ಆಗಲ್ಲ. Revision ಇದೆ.
If the government had fixed his salary from 2005 till 2014, has the salary been paid in accordance with this particular order?
ನಮ್ಮ ಪ್ರಕಾರ ಹೇಗೆ ನಾವು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ನೋಡಿ ನಾವು ಡಾಕ್ಯುಮೆಂಟ್ ಪೇಜ್ 65
Page
65 ಇದರಲ್ಲಿ ಏನೋ ಒಂದು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಕೊಡೋದಿಲ್ಲ ಅವರು. ನೋಡಿ ಸ್ಯಾಲರಿ ಅಂಡ್ ಅಲವೆನ್ಸ್ ಪೇಯಬಲ್ ಫಾರ್ 2005 to 10 11,40,000. ಏನ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಏನೂ ಇಲ್ಲ. ಆಮೇಲೆ ಇಂಟ್ರೆಸ್ಟ್ 9% ಅವ್ರು ಪೇ ಮಾಡೋದು ಅದೊಂದು 10 ಲಕ್ಷ. ಸ್ಯಾಲರಿ ಅಂಡ್ ಅಲವೆನ್ಸ್ 2010 to 2014 ಅದೊಂದು 16,35,000. ಅದಕ್ಕೊಂದು ಇಂಟ್ರೆಸ್ಟ್ 9%. ಆಮೇಲೆ ಎಲ್ಲ ಸೇರಿ 31 ಲಕ್ಷ ಬರುತ್ತೆ. ಈ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಯಾವ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಯಾರು ಕೊಡಲ್ಲ. ಈ ತರ ಡೀಟೇಲ್ ಕೊಟ್ಟು ಪಬ್ಲಿಷ್ ಮಾಡಬೇಕಂತ ಹೇಳ್ತಾರೆ.
From 2010 to 2014, you can't go beyond 9 lakhs because of the order. 2005 to 2010, there's nothing, no determination as whether you were refused work or not paid salaries. This you are raising for the first time after the petition was disposed of.
Government have not paid it.
ಇಂಟ್ರೆಸ್ಟ್ 4% ಬದಲು 6% ಅಂತ ಹೇಳ್ತೀನಿ. ಅಲ್ಲ ಹೆಂಗೆ 2005 to 2010 what basis are you making this claim? There's no determination anywhere. You could have. That is the entitlement. But where is the determination that you were not given work from 5 to 10? There 6% interest ಮಾಡ್ತೀನಿ ಅಷ್ಟೇ for that period. ಇಲ್ಲ ಸುಮ್ಮನೆ ವಿಡ್ರಾ ಮಾಡಿ ಲಿಬರ್ಟಿ ಕೊಡ್ತೀನಿ ರಿವಿಷನ್ ಹಾಕೊಳಕ್ ಅಲ್ಲಿ ಬೇಕಾದ್ರೆ ಎಲ್ಲ ಕಿತ್ತಾಡ್ಕೊಡಿ. As against the impugned order, the petitioner obviously has a remedy of invoking the revision to rejection of the government under section 131 of the Karnataka Education Act. In view of the above, reserving liberty to the petitioner to approach the government under section 131 of the Education Act, writ petition is dismissed. Realist. Who's opposing you? Ready na? Ready or not?
State government, we have sent it to the Department of Director. Now they have sent it towards to the Department of Parliament Affairs. On 21 goes as the meeting. So the government will take 2 months to approve it. From the date of approval and notification of the amended state laws, we will request the use because we have not only for this post, we have more than around 400 vacancies that are posted. We'll have to finalize the vacancy matrix and then take the approval for the reservation matrix. So totally not to dispose of stating that within 6 months, with the entire process. Yes, sir. The meantime, even though the fixer is after the RT application permits the CR, they are not permitted. They are also not permitted the CR. Whether it is experience certificate is mentioned in the CR, only in the notification they are mentioned there. If it is there,
you file a memo. Whatever you said, put it on affidavit, then I dispose it on that basis.
My affidavit is ready. Can you take up?
ಅವ್ರೊಂದು ಕಾಪಿ ಕೊಡಿ ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಹೇಳಿ. ವೆಬ್ಸೈಟ್ ಲಿಂಕ್ ಕೊಟ್ಬಿಡಿ ಅಷ್ಟೇ ಅವ್ರು. ರಿಲಿಸ್ಟ್
I appear, my lords, for I've been engaged to appear for the respondent.
Yes.
Serial number 47.
Matter was heard for some time.
Yes. Problem
Ready, Murthy avare.
Let's kindly see, my lords, in this matter, in the writ petition, kindly see the prayer of the petitioner. Page 18 may be seen of the writ petition where the appointment of the petitioner is appointment of the petitioner, my lords, is of a temporary nature. Page 18. Kindly see last but 3 paragraph. The appointment is initially temporary for a period of 3 years and may be regularized through a process of assessment subject to the minimum eligibility criteria for the post being met. It is terminable by giving in writing a month's notice on either side and will be governed by the general terms and conditions of the institute in force from time to time. Now kindly see page 15, my lord, the prayer. Kindly come to the prayer.
Yes.
That issue a writ, order or direction in the nature of mandamus, directing the respondents to consider the petitioner as a regular or permanent employee of the respondent number of institution by considering his representation dated 1/7/2019, annexure J, and in terms of annexure C, D, and annexure E. So the prayer is only to see that his representation to be considered. Earlier also he had given a representation. On certain valid grounds, the representation was rejected, and he was also told why he cannot be made a regular employee. Now, the worst scenario will be, my lord, that the institute may be directed to consider his representation. But before your lordship could take any decision in the matter, a few more facts are very relevant. Now, kindly see, my lord, para 2 of the writ petition, where the petitioner is currently working as assistant professor, Department of Mechanical Engineering at the respondent number 1 institute for the past year without any interruption, blemish. Now, para 4 he says, petitioner was appointed in the aforesaid post following a rigorous selection process, and the respondent number 1 issued him an offer letter appointing him to the post of assistant professor grade 2 in the Department of Mechanical Engineering, IIT Dharwad. This, my lord, is a misrepresentation. Because as I read his appointment order, he was not appointed in the post of assistant professor grade 2 at all. It was a temporary appointment. The impression that he was appointed there, he was working for 3 years, gives a totally incorrect position of what he is seeking.
What are the terms and conditions of your these rules that are framed? What are the rules that are framed for recruitment for this IIT?
Yes, Milan. I point out to you. Page. Now there's a lot of confusion because there are two petitions, my lords. I don't understand which of the petition I should take, but I've made some notes and for pointing out the conditions of
I only have WP 242 but 2021. Which is the other petition that you are referring to?
ಅಲ್ಲಿ ಏನೋ ಒಂದು ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗಿದೆ ಆ ಅಮೆಂಡೆಡ್ ರಿಟ್ ಪಿಟಿಷನ್ ಇಲ್ಲ ನನ್ನ ಹತ್ರ ಸೊ ಐ ಹ್ಯಾವ್ ಗಾಟ್ ದಿಸ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ and the writ petition. I am going between the two, running between the two papers. Therefore, I may inconvenience the court. Also, kindly pardon me.
Amendment was not amendment application. Amended review was filed on 11/3/2022. 11th March 2022. Copy, sir. To email. Copy attached.
Kindly take, my lord, page 35, my lord,
35 of what?
of statement of objections, my lord.
Can you enlighten me on the rules which govern the appointment to the
Under
side?
the rules, my lords, is page 45 of the objections.
Forty-five.
Page R5.
Page 46. This is an advertisement notification. Where are the rules? I remember that those rules were shown to me on the last occasion.
Yes, my lords, I have the rules also, my lords.
After marking the connect, I will scale it.
Actually, kindly take to R5 minutes.
Pudnalakku?
They call it a fresh compilation. September
99 ಒಂದಿದೆ 19 ಸೆಪ್ಟೆಂಬರ್ ಇದೆ. ಅವ್ರ ಹತ್ರ ಇದೆಯಾ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲರ್ ಇದೆಯಾ?
Page 26 ಅಲ್ಲಿ notification ಇದೆ. Kindly have a look at the notification, my lord. Page 26 of my statement of objections.
The council is referring to the synopsis that he has filed. You are referring to the objections.
Yes, my lord. Because they did not produce this, and I have produced this notification. Kindly see at page 32, clause 12 or whatever I call clause item 12 at page 32. And it starts at page 26, my lord, under the head notification. Could your lordship get that, my lord? In exercise of powers conferred by section 26, read with section 27 of the of the Institute of Technology Act 61, the council with the prior approval of the visitor hereby frames the following first statutes of Indian Institute of Technology, Harvard, namely. Your lordship get that, my lord?
I don't know where you are referring to because 1923. Notification dated 31st of July.
31st July, my lord, 2017.
First statutes.
My lord, literally, the source of the entire in exercise of the powers conferred by section 26, read with section 27 of the Institutes of Technology Act 1961, the council with the prior approval of the visitor hereby frames the following first statutes of Indian Institute of Technology, Dharwad. In this, various definition and powers are given. I would request your lordship to see para 12 at page 32, in page 32.
Yes.
Here, straight away I go to para 2 in this. Following are the powers and functions of the director. The director shall have the power to fix on the recommendation of the selection committee initial pay of an incumbent at a stage higher than the minimum of the scale, but not involving more than 5 increments in respect of post to which appointment can be made by him under the powers vested in him by the provisions of the Act. I take your lordship directly to 4. In exceptional cases, subject to availability of funds, the director shall have the power to create temporary posts with the approval of the chairman of not more than 2 years duration on approved scales of pay under report to the board, provided that no such post of which director is not the appointing authority shall be so created. In fact, this appointment is created under this provision.
Are you saying it is a temporary post then?
Temporary. In fact, it is temporary, my lord.
No, the
Otherwise, where is the need for asking for confirmation?
No.
My friend need not have asked for confirmation if it was not a temporary post.
Para 12(2)(4) relates to the power of the director to create a temporary post.
ಹೌದು ಅದು ಕ್ರಿಯೇಟ್ ಮಾಡಿ ಅಪಾಯಿಂಟ್ ಮಾಡ್ತಾರೆ of which director shall also be a party in the interviewing committee. That is his power under the statute that is given to him, and therefore
are you saying that
one cannot say.
No, are you saying that the post of assistant professor grade 2 in the Department of Mechanical Engineering is a temporary post created?
And temporary post created and given, and therefore your lordship will see the papers are not very properly sitting with me because of various reasons. Kindly see page 45.
I think you should have sat with him and assisted him on the paper.
Temporary employees. The same paper book. Nandu respondent. Page 45. Temporary employees, Madhyadalli. The service of a temporary employee shall be liable to termination at any time by notice in writing given either by the employee to the appointing authority or by the appointing authority to the employee. Period of such notice shall be 1 month unless otherwise agreed to by the institute and the employee. The other terms and conditions of release of such employee shall be as may be specified by the appointing authority in the letter of appointment. So in the letter of appointment also I have said it is a temporary employment and for a certain period, which I read to your lordship at page 18.
No, see, to say you're a temporary employee was one thing. Your appointment letter also says may be regularized through a process of assessment.
Right, correct.
So it's not a temporary appointment in that sense of the term.
It is a temporary employment unless it is regularized in the process of when he joins, there are certain rules that are there as to how he can become permanent.
Which is the provision in this first statutes which permits regularization of a temporary employment.
It is not regularization in the real sense.
The appointment letter indicates that it is a period of 3 years temporarily and it will be regularized. So there must be a corresponding provision under the first statutes which enable such a procedure to be followed. These statutes are clear. You recruit
first statutorily director ge power kottidare
to create a temporary post, not a temporary employment.
Temporary post. A person who takes up a temporary post is a temporary employee.
Show me how it is a temporary post. It is not a temporary post. He was appointed temporarily. The post is permanent.
No, my lords, it can't be, my lord, for this reason. If a temporary employee is appointed to a post, the post may be temporary, but he becomes permanent, or the post is permanent, is not going hand in hand. If I appoint a person for a temporary post, he will hold office only for the period for which I have employed him, notwithstanding what the post is.
Where is the amount of sanctioned post in your statutes? Where is the schedule of employment prescribed, which indicates that this is an additional post created by the director?
As such,
it was all along argued that this is not about a permanent post, but the appointment was temporary for a period of 3 years. The question that I remember raising was Once you say that you are appointing him temporarily, and you also say that you will regularize him subject to an assessment, there
Howdu.
must be a corresponding power under the rules which enable you to evolve this hybrid procedure of appointing somebody temporarily and then regularizing them. You cannot, you are bound by the first statutes. Your appointment can't go beyond the first statutes. You have been given no discretion to play around with the rules. You are bound to follow the statutes.
ಈ ಫಸ್ಟ್ ರೂಲ್ಸ್ ಅಲ್ಲೇನೆ not much on scales of pay under the report to provide no such post appointing authority should be so created. In fact, your lordship, if your lordship sees, it says,
temporary post creation
I think you're not.
The post, your lordship sees this particular clause again.
Yeah, issued by the para 20 of the statement of objection. Absolutely. It is submitted the Indian Institute of Technology, Bombay, had issued an advertisement bearing number 2015, inviting applications from all well qualified Indian nationals, including persons who are so in the department of mentioned so. So it is submitted that the candidates not eligible for the post of assistant professor was also permitted to apply for assistant professor on contractual basis. A copy of the above advertisement is produced and R5. Then you will also be candidate to next parallel. Now I submitted application in person to this. I was selected. Qualification computer the assistant professor of the post. It is not a creation of post. It is not a creation of temporary post.
Brief him again correctly.
You know, if you submit the petition or offer the post, after selection.
Because last time when the matter was heard, what I remember distinctly was that they admitted that this was a recruitment after a selection process was undertaken. But they relied upon that particular condition which said it is temporary. Therefore, I raise this query. Does the provisions, does the first statutes enable you to appoint somebody temporarily and thereafter seek to regularize them? At that stage,
Clause 12 is a part of the first statute. Kindly see page 26. 26 of my statement of objection.
In your objections, you don't even bring forward this argument that it is a temporary post created for the first time. This was a regular post for which an appointment was made temporarily.
No, Millard, I'm sorry, Millard. What it says is, in the very first statutes itself, it empowers the director to create temporary posts. It is very clear.
But in your objections, you don't even contend it's a temporary post. Kindly go see your objections. Your objections does not talk about that at all. The argument proceeded on the footing that the appointment was temporary, the post was not temporary. Their argument advanced was it's a temporary appointment. Therefore, by following the procedure prescribed under the terms of conditions, I could discharge his services. Then this query came up. Can you do this under the regulations? Then the regulations are produced.
Unfortunately,
Then ask him to brief you correctly.
Your lordship wants to know whether this was a temporary post or a permanent post, and whether the director created this temporary post.
No, you are arguing.
If I have understood your lordship right.
You are arguing it for the first time. On the last occasion, this was never the argument. The argument was only on that footing. The argument was of the institute that we have appointed him temporarily. We have the power to discharge his services. Therefore, the reliance was placed on that clause which said that you can regularize them subject to an assessment, and therefore it was not a temporary appointment. Then I asked him to produce the rules to indicate under which power do you have a provision to appoint somebody temporarily and thereafter regularize them. There must be a procedure under the statutes. You can't evolve your own procedure when there are statutes created. At that stage, it took time.
I think I need to have one more look at the statement of objections and find out whether there is such pleading or not, and then come back, my lord.
Relist on.
Eight.
Ready na? What are the charges? Inverter ಎಲ್ಲ ಏನಾಯ್ತು? ಈಗೇನ್ ಪನಿಷ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ?
No application was filed for change of Khata. There was no demand, and it is not my work to change the Khata also. Right of the argument, how necessary to consider the evidence produced by prosecution regarding the alleged work of the complainant pending with the full as on the date of the 27/2014. The result of the developments made in the complaint alleged that the alleged by the complainant that he has filed an application to the town municipality on 28/7/2014 for change of Khata that is taking separate Khata in his name and in the name of his brother Subramani in respect to property bearing his of the province of in order to prove that complainant filed an application for changing separate Khata, the prosecution has produced the original application filed in the complaint dated 28/7/2014 as exhibit B, as rightly contended by the government advocate for exhibit B was filed by the complainant and his brother seeking certified copies of the Khata extract and Khata assessment of the property in assessment number sponsors situated in insurance. The recitals of this exhibit B clearly goes to show that complainant and his brothers are requested only for issuing copies of the Khata extract and his application is not filed for change of Khata or separation of Khata of property into the name of the complainant and his brothers as stated by the complainant before this court. As far as the contents of exhibit B3 and filing of the same is concerned, the complainant is competent person to dispose with regard to the same, but the perusal of examination we did not identify the document XBP as an application filed by him for change of Khata. It appears that the prosecution has cleverly withheld this document from the complainant and did not make any efforts to confront this document with the complainant, know whether the complainant only has filed this application.
ಇಲ್ಲೇನ್ ಹೇಳ್ತಾರೆ ಈ ಎನ್ಕ್ವೈರಿಯಲ್ಲಿ?
Next column, the last next. PWC unequally admitted to a 37/2014 he and his brothers have filed application exhibit P3 seeking extract of the Khata. He has also specifically admitted he has never filed the complainant himself admit that he has never filed an application to the town municipality seeking separation of Khata property. So on the result of exhibit P3 as well as the evidence of PWC it is very much clear that on 37/2014 the complainant filed application PP only for seeking extracts of the Khata and assessment of his property and not for separation of Khata into his name and into the name of his brother as a resident person. We are doubt naturally as I just tell the complainant did not file any application for the Khata separation of Khata, and then he applied only for the copies of the extract and assessment. The person of the complainant approaching the requesting for change of Khata, excluding demanding 2005 for the change of Khata. Next paragraph, paragraph 18. As far as the work, paragraph 18 is not the same page, in this context, it was must argued on behalf of the accused that the accused being a revenue inspector is not empowered or it is not his duty to issue Khata extract and other assessment Khata extract, and such no work of the complainant is pending with the accused as of the date of the alleged exhibit B by the then principal chief officer of the town municipality admits during the course of cross-examination by the accused that issuing of Khata extract is not entrusted to any revenue inspector. He has also clearly admitted that no work of issuing Khata extract on the property of the complainant was pending with the accused at any point of time. So, my lord,
What does he say in the inquiry?
my lord,
Was he examined?
But the inquiry officer informs that my lord that it is my duty. Because we kindly turn to the evidence of the complainant.
What is the finding of the inquiry officer?
That my lord, I have demanded for change of Khata.
ಎಲ್ಲಿದೆ finding? Does it take into consideration this statement? It is enquiry report.
It's 68. It's 58 onward. 11 goes to 58. The consideration, the special city judgment deal now. Special city judgment is later.
Which is the date of the judgment?
Report 2020. Special city judgment 31/7/20.
No, in this, was that request for change of kata made in this, was it produced in the inquiry?
Is admitted that it is
Application.
Is admitted that it is expressed for kata, not the.
Idರಲ್ಲಿ ನಿಮ್ಮ enquiry report ಅಲ್ಲಿ the same document is, then where is the question of change of kata?
Not change of kata, but change of application for kata extract in this. But the and the misconduct itself was all not a expression of the bribe of that led to murder.
Correct. Adu akbittadalla. I'm not into that. Suppose he had demanded some gratification for this change of kata, then this allegation will stand proved. If that principal request was not there for change of kata at all, then how can you hold that the charge was established?
Charge is established to the extent that he committed misconduct, to the extent that he was in possession of the amount he is not supposed to.
Charge note, charge. Charges that he demanded a bribe of rupees 2,000 from so and so, and agreed to receive rupees 1,000 after negotiation to make separate kata for assessment number so and so in his name and his brother. So therefore, two things you have to prove: that the request was made for change of kata, for which this consideration was demanded. If you have not even produced that document which indicates, in the light of the complainant becoming hostile, if there is no request at all for change of kata,
Partly of that, to the extent of what kind of an application.
if there is no document indicating there is a request for change of kata between the complainant and his brother, then will not the entire charge fall down?
There is the application is there, the entire file is there. Just the finding whether it is there, application for kata.
I will ignore the judgment of the Sessions Court for a while. In this enquiry report, where is the document which was produced to indicate a request for change of kata was made to the petitioner?
But exhibit P7, the inquiry is the entire file, whether it contains the application for kata transfer or that observation or.
If that document is not there indicating that there is a change of kata request.
Exhibit P7, the entire file, and put the application on.
Then if I have to go through this exhibit P7, again you rely only upon exhibit P3, which was relied upon in the criminal case. Then if there is no request, how can you?
It has to be the same document, but there is no finding as such. The only based on the admission made by the complainant in both the cases, that inference has to be shown, whether it is an application for kata transfer or kata. A suggestion is made that it is not an application for kata transfer. It is an application for kata. This is yes.
Then what if?
Complaint himself said no demand on the, that's basic 69. There is no demand on the complainant says. The loss by kindly trying to pay.
Did you establish anything to say that the application was filed? He sat on the application for quite a while, or he raised any objections? Anything of that kind? Is there evidence of that kind?
File is seized from him.
File bitbudi adu acquittal agogidiyalla. Acquittal, is there any other file produced to show that you were sitting on the file, there was misconduct on because of that, and if that can be inferred?
To the extent of what the trap being successful, the amount being found in its custody, that is there. But in misconduct or incident,
No, you can independently prove that notwithstanding the acquittal, an application for change of kata was made. He was sitting on the file unnecessarily. He did not discharge his duties, and there was some indication of there being a demand. Is good enough to impose a punishment.
yes, that is there.
But if you don't even establish that request for change of kata was made, the entire basis would fall down, isn't it?
But the transfer itself is not doing. Kata transfer is there. On the application is there.
ಏನೋ ಅಪ್ಲಿಕೇಶನ್ ಖಾತೆ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಕೊಡು ಅಂತಂದ್ರೆ ಹಂಗಾರೆ ನೀವು ಕಾಪಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೆ
Most of the applicants, Kata extract application transfer.
no, the charge is specific, no matter what they ask, your charge is specific, that you wanted Kata to be separated.
But the specific nature of the charge not be created to the final report. Of course, not the charge, you need not inside to the DPO to contest the case.
Can you hold him guilty by inference or by suspicion?
That is not.
One application for issuance of Kata extract is pending. So from that, can it be inferred that he made a demand for?
But demand is good.
Demand is not from the complaint says no demand. Page 69. Page 69 ಅಲ್ಲಿ. ಎರಡು ಸಾವಿರ ಲಕ್ಷ ಕೊಡಬೇಕು ಎಂದು ಕೇಳಿದರೆಂದು ಮಾಡಿದ ಸಲಹೆಗೆ ಸಾಕ್ಷಿ ಅದು ಲಂಚ ಎಂದು ನನಗೆ ಗೊತ್ತಿರಲಿಲ್ಲ. ₹2,000 10,000 ಕೊಡ್ತೇನೆ ಎಂದು ನಾನೇ ಹೇಳಿದ್ದೇನೆ.
ಅದಕ್ಕೆ ನಾವು ಒಪ್ಪಿಕೊಂಡ್ರೆ it's not denying. That clearly established demand. The amount of seized from his custody is there, is related to the demand. Hand was turned in color, all those are there. There is nothing.
For this authority, the complainant has disclosed before about the demand of each of as a payment of has not agreed for the sale and got a complaint. Except this does not.
This is what I was talking about, Arbati. Once you are the prosecutor there and you are the.
ಈ inquiry-ನಲ್ಲಿ ನನ್ನ only the investigating officer comes as a witness. The inquiry officer is different.
No, the charge you had to establish was that an application of change of Kata was made, and in order to accept that application, he made a demand. If that application itself is not produced before the inquiry officer also.
But he admits DG enter. Para 28 is the para 27 is the But what exhibit P7 is speaking about, not the reference in para 26 about half portion of marriage. 26, the IURB cross-examined the advocate for DGO. When 6 IUR denied. The main defense of the DGO is that.
Where is he admitted that a request for change of Kata was made?
But that is not in so many words.
There are so many words, but he should specifically admit ಹೌದು ಅವ್ರದೊಂದು ಅರ್ಜಿ ಕೊಟ್ಟಿದ್ರು ಖಾತೆ ಚೇಂಜ್ ಮಾಡೋದಕ್ಕೆ ಸಪರೇಟ್ ಮಾಡೋದಕ್ಕೆ ನಾನು ಅಂತ ಹೇಳಿದ್ರೆ ಒಪ್ಕೊಳ್ತೀನಿ. This is a general description of his work.
That is 27. 26. The cross-examination of the IO. The IO has been cross-examined when the advocate for DPO for which the IO has granted the main defense of DPO is that the complaint gave property. He has relied upon activity some which is the control details of the office of the government. In this exhibit piece of seal number 15, the name of this complaint as applicant and so and the date time as 30/7/2014 for Aadhaar extract. Further, it also released the status as pending.
That is his argument that he had applied only for Kata extract.
So some work is pending, but it is not
Dismissing an employee on.
Regarding punishment, there are findings about demand about.
Like ಇವಾಗ ಪನಿಷ್ಮೆಂಟ್ ಏನ್ರ ಮೇಲೆ ಕೊಡ್ಲಿ ನಾನು ಅಪ್ಲಿಕೇಶನ್ ಇತ್ತು ಅವ್ನ ಮುಂದೆ ಅಂತಾನ on what basis do I punish him?
But
is able to point out the mitigating factor. Because there is finding.
No, if I'm unable to even come to the conclusion that there was a valid charge made and established, what punishment did I record?
Charge, yes, ma'am, your lordship are right, transfer of khata. Your lordship, you also see the finding. For transfer, issue of khata extra, you have to first transfer the khata. That also has to happen.
Khata extract is different, khata transfer is different.
Khata transfer application might be different in terms of the use of the words it will be different. Your lordship can see the findings also in 27 part. There, khata extract cannot issue because our ibbru brothers partition ಮಾಡ್ಕೊಂಡಿರ್ತಾರೆ ಇಬ್ರು ಸೆಪರೇಟ್ ಖಾತಾ ಮಾಡ್ಕೊಳ್ಳೋಣ ಅಂತ
ಆತರ ಹೇಳಿದಾರೆ ಎಲ್ಲಿ ಹೇಳಿದಾರೆ ಆತರ ಇವರೆಲ್ಲ ಒಪ್ಕೊಂಡಿದ್ರು ಹೌದು ಬಂದ್ ನಂಗೆ ಖಾತಾ ಬೈಫರ್ಕೇಟ್ ಮಾಡ್ಕೊಡಿ ಅಂತ ಕೇಳಿದ್ರು ನಾನು ಅಪ್ಲಿಕೇಶನ್ ರಿಸೀವ್ ಮಾಡ್ಕೊಂಡೆ ದಟ್ ಇಸ್ ನಾಟ್ ಇಸ್ ಡಿಫೆನ್ಸ್ ಎಟ್ ಆಲ್
but the applicant the complainant could approach the DTO only for the purpose of
again this is another assumption isn't it
it's not an assumption but it is there on record the evidence of the complainant will be one. He says but at the end of page 30 at page 66 here the complainant sheet is got it as a equivalent report and stating that 4 waiting states security stand jointly in his name and his brother. So in order to change the khata security in his name as well as brother's the name of his brother, he met the DTO principal office total. He gave an application for change of khata. DTO
ಅದನ್ನ ತೋರಿಸಿ if you show the application that he was given for change of khata then there is a charge ಅದೇ ಅಲ್ವಾ that is a fundamental problem.
If you lordship strictly look at the charge, not for in an inquiry, not but the work is pending.
No, the charge categorically states request for change of khata was made, for which a demand was made. If you are not able to establish that request was change of khata itself was made, then on what basis are you going to say that he made a demand?
Demand also is there.
ಅಲ್ಲ ಇದು ಬೇಸಿಸ್ ತಾನೆ.
Exact use of change of khata transfer, khata extra. This is the difference, not in available. Exhibit P7 also the IO says. PWC IO says.
You only help such people get a reward.
There are 26. IO says not
Khata extra, it is not my work of changing khata or giving the khata extra.
So our admit ಮಾಡ್ತಿದ್ದಾರೆ ಖಾತೆ ಬದಲಾವಣೆಗೆ ಅವರು ಸ್ಥಳ ಪರಿಶೀಲನೆ ಮಾಡಬೇಕು ಅಂತ
Same set of evidence below, same set of fact. Same evidence led by in the inquiry and in the trial court also.
Reserve. Very good. Hearing matters, I won't be taking up at 2:30. I'll only go with the remaining. No, I'll continue this list. I will be raising a bit early, so I will not take up hearing matters. From serial number 7, from serial number 73, I won't take up. Continue agate. List continue ಮಾಡಿ.
Lord 57, Lord, I appear for the petitioner. But I have some urgency in the matter, Lord. Lord,
Take
what
it.
he has some difficulties, what he's saying.
Ah. Then I'll have to take up hearing. 54 and? Realist.
Lord,
68. Realist. ಯಾವ್ದ್ರಲ್ಲಿ? Realist. Please wait.
Court officer. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಯಾವಾಗ ತಗೊಳ್ತಾರೆ ಮೇಡಮ್?
ಸರ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಬೆಳಗ್ಗೆ ಅಜ್ಜನ ಆಯ್ತು ಸರ್, ತಗೊಳ್ಳಲ್ಲ, ಎಲ್ಲ 7th ಹೋಗಿದೆ.
ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಸರ್ ಹಿಯರಿಂಗ್ ಮ್ಯಾಟರ್ ತಗೊಳ್ಳಲ್ವಾ ಸರ್ 73 ಇಂದ? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್.
ಹೇಳಿ ಸರ್.
ಸರ್ 73 ಇಂದ ಹಿಯರಿಂಗ್ ಮ್ಯಾಟರ್ ತಗೊಳ್ಳಲ್ವಾ?
ತಗೊಳ್ಳಲ್ಲ ಇವತ್ತು.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಸರ್, ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಡೇಟ್ಸ್ ಕೊಡ್ತೀವಿ ಸರ್.
Lord's kind leave, my Lord.
Yes.
I'm sorry, 57, Lord. Developed slight temperature. Lord, I actually opposed in the afternoon. I wanted to argue the matter with the urgency. Because I'm feeling a little uncomfortable.
All right.
Lord, I spoke to my learned friend. He's fine with 12. Well, it's convenient to my lords.
Well,
Lord, can it be listed for hearing on IAM, Lord? Because it can be.
if you want, I'll have it at 4:30.
Very well. Grateful. Obliged. 12th, 4:30. Grateful.
Narrowed bench matters. Then we will be number one, Rajshekar Purji.
Lord, I appear with the petitioner in this case.
ಸಾಕಿದಾರಾ?
ಇಲ್ಲ ಹಾಕಿಲ್ಲ ಇನ್ನು ಅವರೇನು ಕಾಪಿ ಇಸ್ ನಾಟ್
Appearing on behalf of respondent in first matter and connected matter petitioner, my lord.
ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರ ಮೇಡಮ್?
My lords, petitioner is arranging money, my lords. A week's time, my lord.
You have so much of money and for 6
My lords,
lakh.
petitioner's fathers were administered, my lord. No, my lords, he is not having money, my lords. All the money has been spent in his father's hospital, my lords.
Realist. Council seeks for 1 more week's time to make the deposit.
Much obliged, my lord.
Next time I'll proceed to pass orders.
Please, my lords.
Ambekar ಅವರೇ.
Seal number 2, Shri Ambekar. Seal number 3.
I am for the petitioner in this matter, my lord.
Yes.
My lord, appointment order, my lord, he has been appointed as a peon. My lord, subsequently, my lord, criminal case has been registered against the petitioner. Thereafter, my lord, cancellation order has been issued, my lord. Objection is filed, my lord. I have received objection, my lord.
Yes. Pass over. File ಮಾಡಿದಿರಲ್ವಾ?
ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. It is sent, my lord. I have received.
What have they said in their objections?
My lord, notification is produced, my lord, according to which it is, my lord, stated, my lord, immediately, my lord, after issuing of appointment order, they have to be, my lord, accommodated, and my lord, they have received, my lord, police report subsequently. Therefore, my lord, after receipt of police report, they have, my lord, taken action. That is the, my lord, contention of the, my lord, respondent.
When were you appointed?
My lord, I have been appointed on, my lord, 7/6/2023, my lord. And my lord, till, my lord, 28/7/2023, he has worked under the, my lord, court, my lord, as a peon. Thereafter, my lord, cancellation order is passed.
No, did you disclose in your application that?
My lord, as on date of, my lord, my application, there was no case was registered, my lord. After, my lord, I have been after, my lord, interview application, my lord, case has been registered, my lord, and subsequently, my lord, I have been selected. Thereafter, notice has been issued where, my lord, I have given reply saying that, my lord, for there is a, my lord, civil dispute between the parties. For that, my lord, there was a case is registered against the petitioner. Case and counter case is there, my lord. After my lord, reply notice, my lord, appointment order has been issued, my lord. Applications were called for, my lord, on 28/11/2020, and application is filed on, my lord, 15/12/2020. Case came to be registered on, my lord, 19/5/2022, my lord.
What stage is the trial now?
My lord, charges are framed, my lord. My matter has to be posted for evidence, my lord.
You got a notice from the SP Bidar.
My lord,
Where is the notice that you got from the SP Bidar regarding the selection?
my lord, annexure R5 is produced by, my lord, respondents. My lord, it is in page 19, my lord. They requested to, my lord, furnish report with regard to, my lord, appointment orders passed against, my lord, petitioner and others.
Where is the order of appointment?
My lord, appointment order is, my lord, at my lord, ink page, my lord, 53, my lord. Annexure H, my lord. Serial number 1, my lord.
Yes, where is Madhukar? I'll have it next week. Find out what stage that criminal case is.
Please, my lord, I'll verify and I'll submit. Next Friday?
Yes.
Much of it.
Serial number 1, Shri Jeevan Kumar.
Name challenge ಮಾಡ್ತಿದ್ದೀರಾ?
Notice has been issued at page number. Annexure H, page number 30, as to why it should not be removed from the source without there being any inquiry.
Criminal case was conducted by the ACB. The criminal case was still.
What is your work?
Village assistant. Because I am only to assist the village accountant and I have no role to play in that. Any proceedings with that. If my lords would kindly take page number 27.
Next, which is a show cause notice.
It is a show cause notice. They have decided terminate. Kindly take page number 27. This is the letter taken by the principal secretary asking him to remove from the work by issuing a notice. There is no inquiry being conducted. Kindly take page number 28. Lokayukta sends a report under section 12(3) to act according to.
ನಿಯಮಾನುಸಾರ ಅಂತ ಹೇಳಿದಾರಲ್ಲ ನಿಯಮಾನುಸಾರ ಕ್ರಮಗಳನ್ನು.
ಅದು ಲೋಕಾಯುಕ್ತನವರು ಹೇಳಿದ್ದಾರೆ.
Where is the 12(3) report?
12(3) report is a page number 19. Under section 14, no sanction was also been given for further inquiry. Directly the chief secretary writer, principal secretary writes a letter to Deputy Commissioner at page number 28. To issue notice and removing the work. The two recommendations to be accepted. 14 recommendation has to be sanctioned. Sanction on the section 14 will have to be given to conduct an inquiry by the local.
The 12th report ಕೊಟ್ಟಿದ ತಕ್ಷಣ straight away you proceed to terminate.
Page number 28.
ರಿಪ್ಲೈ ಕೊಟ್ಟಿದ್ದೀರಾ ನೀವು?
ಕೊಟ್ಟಿದ್ದೀವಿ.
When a DG accepts notice for respondents released on zone. Until then, no further order shall be passed pursuant to Annexure H. And then no permitting. If you make a statement that you roll an inquiry and then pass appropriate orders, I will close the proceedings.
Okay.
ಯಾವತ್ತು ಬೇಕು ಆಗಿತ್ತು ಸೋಮವಾರ ಶುದ್ಧ ನಮ್ಗೆ ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿ ನೀವು ಯಾವ ಯಾರು ಕಾಪಿ ಕೊಟ್ರಿ?
Next year, being not with the order,
Let him come.
Please. Also, matter, text number 1, number 37.
In there.
I reflected on what you are doing. Make two submissions with respect to law. Like what would happen after a lot of purposes? A list which is otherwise illegal would remain intact. But clearly because floods have come after 8 or 9. That would not be a drawn floods to otherwise to retain a list which is otherwise bad in law. But the second submission is because delay and lack of floods after floods not distinct right. And when flood similarly situated persons are treated, flood are entitled to the same flood. In fact, a lot is considered flood. This very same question of delay and latches by KPTCL in that other judgment. Majestic Lord.
I think the best thing is to issue a rule and keep quiet.
What has happened now?
It's die a natural death.
What has happened now with flood? For document verification, I am out of the list.
I don't consider this petition to be.
I am now pushed out of the list. In the document verification, my name is not even there. But if it was only this, if my name figures in the list, your artist, I think that I will have to go. Now, what has happened is I will lose my employment. I will not get employment.
If you had come earlier, you would have got the benefit.
In that regard, what is Supreme Court would say? that 8 to 9 months is not more than unreasonable delay. And if person approaches after 8 to 9 months, and if the list is otherwise banned, then not your lordships. I'll just place it those two judgments for leave it there because your lordships can consider it. But merely because not. Lalita. But here was a case where the respondent approached the Supreme Court after the judgment of the tribunal, which your lordship find at paragraph number 2. The respondent thereafter filed an original application before the tribunal. But the law alert is stated in para 28 and 29. That I understand your lordship's apprehension, my lord, that the entire selection will be stalled. My respectful submission, two things. One, my lord, it could have been applied, my lord, to all selectees, to all selection. Once, my lord, your lordship's judgment was service jurisprudence award by this court from time to time postulate that all persons similarly situated should be treated fairly. Only because one person has approached the court. That would not mean that person similarly.
Here, nobody approached the court, Prakash. Nobody approached the court for a period of 10 months. I made that remark in the context of the fact that an order was passed in another case for the other cadre. ಇಲ್ಲಿ ಯಾರು ಬರ್ಲಿಲ್ವಲ್ಲ.
This was here was a case that Tahsildar had approached. This was in respect of assistant commissioner.
ಆಮೇಲೆ ಇನ್ನೊಂದು ಯಾವುದು?
The other case it's in respect of seniority. I understand, but I'm just laying out for this. Para 21, internal page 596, para 21. Those there your lordship will get the fact. Para 30 and 31. Para 30 internal page number 600. 30. Once it is established that the seniority list was prepared in contravention of the statutory provisions laid down in 1991, the seniority list could be interfered with. The appointing authority would be bound by the statutory rules and violation or disregard to the statute to initiate the seniority list. The same would be arbitrary beyond the rules and conflict with Article 14 and 15. The only exception to the above would be where there is unreasonable delay which is unexplained.
To my mind, there is unreasonable delay.
This next paragraph, 10 to 11 months, this is exact.
They are dependent on facts, Budiyar. Chadana.
Para 40 months, very 44. If the seniority list is allowed to be sustained, the engineers who are more meritorious in mechanical and civil seats and the juniors of others would be deprived of their right to be considered for.
See, these are all cases where their appointments were there, some would happen. Here, you're
no appointments are yet made. Document verification is still underway. What will happen is 33% will go, 33% will come in. Because not ultimately affected persons are only 32.
No, that's all.
That's all.
That will be dismissed. Reasons.
Great.
Number 49.
And the inquiry. After entry of
Next year, P, na?
Yes. Please be calculated on the
You admitted the charge against him. Page 61.
That is what they say, I have not making, I am not making it. And
This what they say, ಇದಕ್ಕೆ ಬದಲಾಗಿ ಮೇಲ್ವಿಚಾರಕರ ವಿರುದ್ಧ ಗುರುತರ ಅನಧಿಕೃತ ಹೊರಪದ ಇದ್ದು ಕಾರಣ ಮೇಲ್ವಿಚಾರಕರಿಗೆ ನೋಟಿಸ್ ಮಾಡುವುದು
they produce a letter on a blank paper, the signature was taken. There is no inquiry at all. Order of dismissal.
Where is that letter?
I am representing on the rest of the 12 3. Today I have filed a request for okay.
You're appearing for
2 and 3. Allegation I made against the respondent for 2 years. I am short for time. For any objection I will file the document. Why I am submitting it? Connection of P. Page number 56.
yes.
In that page number 8. Number 8. Para number 4 and 5. I think there is 4 and 5. Hello. ಮೇಲ್ಮನವಿದಾರರ ವಿರುದ್ಧ ಇರುವ ಹಣದುರುಪಯೋಗ ಆರೋಪಗಳಿಗೆ ಪಂಚಾಯತ್ ಅಧಿಕಾರಿಗಳು ಪತ್ರ ಸಂಖ್ಯೆ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಶಿಸ್ತು 1/2018 ದಿನಾಂಕ 3/31/12.
Where is the letter where she
Sort of time I have to bring. Why is now before it was the English Gram Panchayat. Now it is changed as Rural Gram Panchayat.
released on the next date of hearing.
Yeah. Suppressing all of that.
R2 and R3 shall produce the entire records leading up to the termination of the petition. 11th. Huh? ನಾನು ಹೇಳಿ ಡೇಟಿಗೆ ಅವ್ರು ಕೊಡ್ಬೇಕಂದ್ರೆ ನೀವು ಹೇಳಿ ಡೇಟ್ ನಾನು ಕೊಡಕ್ಕಾಗಲ್ಲ ನೋ ಅಂತ ಹೇಳಿಬಿಡಿ. You want me to pass an order to get him here? ತರ್ಸಿ 11th ಅಷ್ಟು ತರ್ಸಿ.
I appear for the petitioner. This is a matter relating to this daily wage employees, my lord. Last occasion, your lordship heard the matter for some time. The petitioners, my lord, are seeking for the prayer as sought for.
ನೀವು ಅಸೋಸಿಯೇಷನ್ ಫೈಲ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ ರಿಟ್ ಪಿಟಿಷನ್.
Association ಮಾಡ್ಬೋದು. Your lordship kindly see there is already one order by the other bench, coordinate bench of this honorable court, my lord. Page number 43, annexure G.
Members can ask, why do you want to file this through the association?
Illa, my lord. Last occasion, your lordship asked to pay the court fee for each person. I have paid the court fee also, my lord. Last time. Court fee each immediately. Total number of members of association basis, but court fee I have paid.
ಯಾವತ್ತು ಕೊಟ್ಟಿದ್ದೀರಾ? ಕೊಟ್ಟಿದ್ದೀರಾ?
I will just verify and submit because last occasion I had told next week.
ನೋಡಿ ನಾವು ಫಸ್ಟ್ ಕೋರ್ಟ್ ಫೀ ಕೊಟ್ರ ನೋಡೋಣ.
Number 52, BS and Bill.
The Mangalore. Wednesday. When do you want it? Wednesday. Dinakar MP.
Please, Krishna. Last occasion, my lords were pleased to direct the respondents to seek instructions. There pensionary benefits or disburse madilla.
ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರು?
Respondent ಗೆ ಅಚ್ಚಪ್ಪ ಸರ್ appear ಆಗ್ತಾರೆ. 1 year ಆಗಿದೆ. ಲಾಸ್ಟ್ ಇಯರ್ ಡಿಸೆಂಬರ್ ಅಲ್ಲೇ ಅವರು ರಿಟೈರ್ಡ್ ಆಗಿದ್ದಾರೆ. 1 ವರ್ಷದಿಂದ ಅವರು they have not even disbursed the pensionary benefits.
Did not come today.
Some urgency in this case, blood.
ಕನ್ಸಿಡರ್ ಅಂತ ಡೈರೆಕ್ಷನ್ ಕೊಡ್ಲಾ ಕನ್ಸಿಡರ್ ಅಂತ.
Now, Ramelinda, my respectful submission is that, my lord, they may say that there's a criminal case pending. At the investigation stage, and your lordships are very well aware of the position of law. Adu barodilla, and they have not even given endorsement.
Your prayer is only to direct them.
Certainly, my lord, certainly, my lords. If in case they reject, my lords, I may have again file a fresh writ petition is my concern.
Then let's wait for him.
Any short date may be accommodated. Great.
Who's opposing you?
In fact, our employer is the management. Management first is aware of it. Reason for it is there. First, they choose to appoint him first. However, the department says I will not approve the appointment for the reason that. But there is no such power available to the department. To delay the extension of criteria or the non.
No, then let the management pay you the salary. Why are you worried with them? If you want their money.
But there is no such provision. Let them show the provision. There is no such provision. It says that they will not be granted.
What is it?
Numbers, they issue an endorsement with the petition of the petition. Next year, yes, numbers is the endorsement issue. Which I challenge not the application.
ಹಾಕಿದಾರ ಅನಕ್ಷರ
The application is what is right. And then
ಇನ್ನು ಲೈಫ್ ಅಮೆಂಡ್ಮೆಂಟ್ ನನ್ನ ಹತ್ರನೂ ಅನಕ್ಷರ ಎಷ್ಟಿಲ್ಲ ನಮ್ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇದ್ದಂಗಿಲ್ಲ. ವಾಟ್ ಇಸ್ ದಟ್ ಎಂಡೋರ್ಸ್ಮೆಂಟ್? The recommendation was to approve the appointment of all others except you.
But what the recommendation was made with respect of all. Also, what the agreement company said the approval.
In para 5 of their objections. That is what they state.
That is from the agreement company, the recommend approval of other candidates, not accept the petition.
So therefore, how can they approve the?
That could not have been done towards my case.
Where have you challenged R2?
Towards by filing towards. Towards challenge the endorsement which is issued, but not the.
No, but until you challenge this recommendation, this is the basis for them to refuse your approval.
That is so much my issue is this. But the agreement committee towards the DDPA but they have no powers under the rules to either not approve or deny. They are only not recommended authorities.
They're only rubber
The
stamps.
decision is not made by the director or the commissioner as the place.
ಯಾವ್ದಕ್ಕೆ ಹೈಸ್ಕೂಲ್ ಯಾವ್ದಕ್ಕೆ
High school annexure 1 notes of the Indian rules.
You are the management or you are the employee?
That was Krishna, I feel. And then endorsement came to issue the dependency.
Rule?
Candidates.
The procedure to be followed, isn't it?
Yes.
This does not
Confer any powers notes on the payment committee or the deputy director. But to either accept or reject the proposal, they can only forward it notes with the recommendation.
read rule 7.2. 7.2.
The inclusion of the name of the candidate shall not come from any right of.
No, rule 7 to appointment of candidates.
7.1.
After 7.1, this is to be sent to that screening committee.
3 years, 7.1 and 8. Proposal shall be sent to the competent authority in respect of the candidate whose names are included in the list published in +1 of clause 6. The competent authority shall, after verifying the selection procedure as prescribed under the rules have been compared, convey approval of appointment to the selected candidate. That is not the director. Prior to that, not is
ಯಾವ್ದು ಓದ್ತೀರಿ ನೀವು?
not annexure 1 to be used.
No, I'm seeing rule 7. Annexure.
Annexure one.
I have annexure 1.
That includes, after the 5 about the interview. The 6 list of selected candidates.
No, before that. Rule 7 subclause 1, the para 7(1).
Proposal shall be sent to the.
The list of candidates whose names are included in the list published. Proposal shall be submitted.
The competent authority shall after the reference. As prescribed under the rules have been compared with, and the proposal of selected candidates.
ಎಲ್ಲಿ ಓದ್ತಿದ್ರ ಅದು? I am referring to this. It says the competent authority shall, after verifying that the selection procedure as specified under the rules has been complied with, shall cause to place the proposal immediately before the screening committee through the concerned chief executive officer. The screening committee shall consist of the following. Then subclause 2, para 2. The chief executive officer of the concerned Zilla Panchayat, on receipt of the proposal of the competent authority, shall send it to the member secretary of the screening committee for preparation of background notes and other materials connected to the selection of candidates. Further, the member secretary shall prepare the relevant background notes and place the same before the screening committee, and also on the conclusion of the deliberation of screening committee shall prepare proceedings of the committee and obtain signature of the chairman and member of the screening committee and forward the same to the competent authority along with all relevant documents for issue of necessary.
Screening committee forwards.
Then what is the point of preparing a background note and then the very purpose of screening committee? Selection is by the
Next, numbered and shall first. And shall make recommendations either for approval or rejection of the selection made. The competent authority shall consider the recommendations of the screening committee and take a decision with regard to approval or rejection.
This screening committee has not sent your case for approval.
No, they say that except the case of the.
So it is not sent for, there is no recommendation in your favor.
That's the reason not side.
If there is no recommendation.
Yeah, to send my name also for consideration.
If the screening committee has chosen not to recommend you,
Please.
what is it that can be approved? If you were recommended, then there is an obligation for them to either approve or not approve. When your name itself is not recommended. That is the very objective of having a screening committee, isn't it? Whether they would wish to have a person like this, they're going to screen your background and then make a recommendation. If they don't want you.
My lord, in serial number 60.
Sir,
Pray for some time, my lord. Statement of objections ಹಾಕ್ಬೇಕು ಅದು ಕಳಿಸಿದೀನಿ ಬಂದಿಲ್ಲ ಇನ್ನು ಅದಕ್ಕೋಸ್ಕರ ಅಷ್ಟೇ.
23 ಬಿಡಿ, still early, you're still young. You list 23 ಇದ್ದಾನೆ, WP of 23.
ಹೌದು.
The case is very young ಅಂತ ಹೇಳಿ.
Qualification of graduation is not considered for the.
ನೋಡಿ, next time mark your objections.
Definitely, madam. ಬೇಗ ಹಾಕ್ಸ್ತೀನಿ.
Next year. Thirty. Next page 30 is annexure E. 4323 alva?
application where I upload this document.
Then outsource ಮಾಡಬೇಕು ಅಂತ.
Aid model. In the year 2015, my appointment was confirmed without aid. Then I have started before the revision petition. The revision petition was approved the connection C.
Next year.
C. In page number 25. C. In operating portion, the 26 bottom. Page number 26. ಅದೇ ಪ್ರತಿವಾದಿ ಮೂಲ ದಾಖಲಾತಿ ಅರ್ಜಿದಾರರ ನೇಮಕಾತಿಯಲ್ಲಿ ಅನುದಾನ ಸಹಿತ ಅನುಮತಿಸುವಂತೆ ಕೋರಿ ಸಲ್ಲಿಸುವ ಪ್ರಸ್ತಾವನೆ ಮುಖ್ಯವಾಗಿ ಪರಿಶೀಲಿಸಿ ಅರ್ಜಿದಾರರ ನೇಮಕಾತಿ ಅನುದಾನ ಸಹಿತ ಅನುಮತಿಸುವ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಪ್ರತಿವಾದಿಗಳಿಗೆ ಈ ಪ್ರಕರಣವನ್ನು ಇಚ್ಛಿಸಲಾಗಿದೆ. ಆಮೇಲೆ ಆದೇಶವನ್ನು ಮಂಡಿಸಲಾಗಿದೆ. 22
Yeah, when was the amendment?
He was appointed in the annexure A. That is in the year number 5.
Now, where is the order appointing you without aid?
That is in 2015, in annexure B. Annexure BLA, these have produced in annexure A. That annexure B is
How can you apply this amendment of 17 to this order?
Number 4. 2017 amendment is one of the reasons that it is prospective for the institution itself. The point when it was considered 2008 when the proposal for appointment and admission into the company was submitted. The applicable rules are the 1999 rules. I have produced on record with my registration. There is only one group D post in the secondary high school in my high school. There is already a person whose appointment was confirmed with granted serving at that post. So from 2008, when the proposal was submitted by the petitioner, the basis for rejection was not the 2017, because that under the 1999 there is already 2 people serving in a group. Hence it was rejected. The review petition at annexure C, it is a direction for consideration. The submission made in the review petition was, my name is not included in the 2015 list of submission consideration by the government. The review petition says memorandum is taken on record, matter to be considered by the relevant authority. In my objection, what I have stated as an institution, from 2015 we have been on unauthorized absenteeism. The abandoned the school, we have not come for the last 8 years. The block education officer has taken the exact same contention. The state government has produced the attendance record, I have produced the attendance record, to say that we have abandoned the school from 2009 to 2015, multiple times we didn't come. Even if all of this is kept aside, the fact of the matter remains that at the relevant time of considering his proposal, admittedly, I have produced the appointment order for the other group D post. There was no group D. In 2017, the government said all group D posts are abolished. If you have anyone who works for you, it may be outsourced. So whether the 2017 issue applies to me or not, today there is no basis for this appointment. I need to abandon this. And that is also the state government restriction that no one is allowed to obtain a benefit of the court when they have not conducted this. All of that is
Is he correct when he says the approval was sent for your appointment in the year 2008? You accept that? You accept that it was rejected on the ground that they could only have one approved group D post and not, no, on facts. You admit that your request, their proposal for approving your post was rejected on the ground that only one post could be admitted to a salary grant?
Yes, sir. In 2015, they have considered.
So your fundamental proposal was for being admitted to salary grant for a group D employee. There are already more than one employee is working as group D.
So not they have confirmed my appointment.
The rejection in the year 2009 by the government was on that ground.
That one have challenged before the revision petition. And it is meanwhile.
Where have you challenged the revision petition?
Revision petition annexure C.
Where is the order that you challenged there?
Here that you have mentioned that there is variable part of it. ಅರ್ಜಿದಾರರು ಪ್ರಸ್ತುತ ಪುನರೀಕ್ಷಣಾ ಅರ್ಜಿಯನ್ನು
Para 26, page 26 ಅಲ್ಲಿ ಹೊರಡಿಸಿರುವ ಆದೇಶವನ್ನು ರದ್ದುಗೊಳಿಸಿ. Where is this Imbara 21/24/1/2009?
This is all on from the review petition that is cited here. The review petition is produced along with my statement of objection.
They have that time they have filed the objection to the also. That time the institution itself is recommend the case to the petitioner. In the year 2022, they have given the statement where he is still working. Copy it for me. But that is not here. So because of the
In fact, the review petition that was filed by them, they admit that the block education officer has rejected the proposal on the ground.
No, what is annexure B?
Annexure B is only. That 2015 is also like that. Only the para is working. Later the ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖಗಳ ಸಂಬಂಧವನ್ನು ತಿಳಿಯುತ್ತಾರೆ. ಉಲ್ಲೇಖಗಳ ಸಲ್ಲಿಸುವ ಮಾಹಿತಿಯನ್ನು ವಿವರಗಳು ತಮ್ಮ ಆಡಳಿತ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುವ ಖಾಸಗಿ ಅನುದಾನಿತ ಪ್ರೌಢಶಾಲೆಯಲ್ಲಿ ಗ್ರೂಪ್ ಸಿ ಮತ್ತು ಗ್ರೂಪ್ ಬಿ ಹುದ್ದೆಗೆ ದಿನಾಂಕ 2/2/2000 ಪೂರ್ವದಲ್ಲಿ ನೇಮಕಗೊಂಡು ಕಾರ್ಯನಿರ್ವಹಿಸುವ 94 ಬಿ ದರ್ಜೆ ನೌಕರರನ್ನು ಅನುಬಂಧ 1ರಂತೆ ಅನುಬಂಧ 1 ಇದು annexure A. Annexure A
ಓದಿ ಪೂರ್ತಿ.
serial number 5 ಅಲ್ಲಿ ಇರುತ್ತೆ. ಲೋಕಲ್ ಪ್ರೌಢಶಾಲೆಯಲ್ಲಿ ಲೊಕೇಶನ್ ಇದೆ. 94 members ಇದು ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೆ. ಮಂದಿತಾತಿ ನೀಡಲಾಗಿದೆ ಎಂದು ತಿಳಿಸಿದರು.
Are you saying that from as per this order dated 1/4/2015, your post was admitted to grant? Then why did you file the revision?
Revision pending is pending is in appeal ಅಲ್ಲಿ. Then they have ಅನುಮೋದನೆಗೆ ಸಹಿತ ಬೇಕು ಅಂತ they have given without aid ಅಂತ ಕೊಟ್ಟಿದ್ರು.
ಇನ್ನೊಂದ್ಸಲ ಓದಿ page 21.
21
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ
ಸಂಬಂಧಿಸಿದ ಉಲ್ಲೇಖಗಳ ಗಮನ ಸೆಳೆಯುತ್ತಾ ಉಲ್ಲೇಖಗಳಲ್ಲಿ ಸಲ್ಲಿಸುವ ಮಾಹಿತಿ ಹಾಗೂ ವಿವರಗಳನ್ನು ತಮ್ಮ ಆಡಳಿತ ವ್ಯಾಪ್ತಿಗೆ ಖಾಸಗಿ ಅನುದಾನಿತ ಪ್ರೌಢಶಾಲೆಗಳ ಸಿ ಮತ್ತು ಬಿ ಹುದ್ದೆಗೆ ದಿನಾಂಕ 2/2/2000 ಪೂರ್ವದಲ್ಲಿ ನೇಮಕಗೊಂಡು ಕಾರ್ಯನಿರ್ವಹಿಸುವ 94 ಬಿ ದರ್ಜೆ ನೌಕರರನ್ನು ಅನುಬಂಧ 1ರಂತೆ 15 ಬಿ ದರ್ಜೆ ಅನುಬಂಧ 2ರಂತೆ 25 ಮತ್ತು 28 ಬಿ ದರ್ಜೆ ನೌಕರ ಅನುಬಂಧ 3ರಂತೆ 5 ದ್ವಿತೀಯ ದರ್ಜೆ ಸಹಾಯಕರ ಅನುಬಂಧ 4ರಂತೆ ಪಟ್ಟಿ ಮಾಡಿ ಸದರಿ ನೌಕರರನ್ನು ಭವಿಷ್ಯಾರ್ಥವಾಗಿ ಅನುದಾನಕ್ಕೆ ಒಳಪಡಿಸಿ ಆದೇಶ ಹೊರಡಿಸಿದ ದಿನಾಂಕದಿಂದ ಜಾರಿಗೆ ಬರುವಂತೆ ಅನುಮತಿಸಿ ಕೆಳಕಂಡ ಷರತ್ತು ಮತ್ತು ನಿಬಂಧನೆಗಳಿಗೆ ಸಂಬಂಧಿಸಿ ಅದರ ಅನ್ವಯ ಆಧಾರ್ ಪ್ರಕರಣವನ್ನು ಮಾತ್ರ ಅನುದಾನಕ್ಕೆ ಒಳಪಡಿಸಲು ಮಂಜೂರಾತಿ ನೀಡಲಾಗಿದೆ. ಈ notification states in that where they have given
was
an order that does not confirm the appointment.
no, it says that is she one of the 94 group D posts that is referred to in the order?
My lordship, my understanding and instructions are they are not produced to annexure to this order. Annexure A is ಅನುಬಂಧ 1. Annexure A, his name is included. Next to his name at serial number 17 it says not confirmed. So we don't have this letter page 13 ಅಲ್ಲಿ annexure A one says my lordship, I let my learned friend complete and I will take over. These are not your false submissions that are being made.
ಅನುಮೋದನೆ ಆಗಿಲ್ಲ ಅಂತ ಇದೆ.
ಆಗಿಲ್ಲ ಅಂತಾರೆ. ನೆಕ್ಸ್ಟ್ ಇಯರ್ ಲೋಕಲ್ ಪ್ರೌಢಶಾಲೆ
for revision attachment, they have the article institution of the party and commission.
Madam, annexure C only says consider. It does not say admit you to grant.
ಸಹಿತ ಅಂತ ಹೇಳಿದ್ರು ಅನುದಾನ ಸಹಿತ ಅನುಮೋದಿಸುವ ಕುರಿತು ಅಂತ ಹೇಳಿದ್ರು.
ಕುರಿತು ಕ್ರಮ ಕೈಗೊಳ್ಳುವಂತೆ.
ಅನುದಾನ ಸಹಿತ ಅನುಮೋದಿಸುವ ಕ್ರಮ ಕೈಗೊಳ್ಳುವ ಪ್ರಕರಣವನ್ನು ಇತ್ಯರ್ಥಪಡಿಸಿದೆ. The objection filed by the institution that before the revision attachment. intended to be replaced the claim. Recommended maintenance of 10/3/2012. Annexure K. Case number 4. Focus on the find the objection to before the
What is annexure R5?
R3 R3.
This was what you challenged on 24/1/2009 under annexure C. Annexure C adalla. Your wait, annexure R5, R6. Read R6 to their objections. That is what you challenged. Annexure R6 was what you challenged before the revision in revision. 2009. Annexure R6.
2009. These are other entry after the okay, R3 notice.
The same was challenged in before this revision of the President Saran was appealed 12 of the court window.
This order has not been set aside to this annexure R6. Revision allow madilla prayer. This revision is allowed on the ground. ಕ್ರಮಶಃ ಕ್ಯಾಂಡಿಡೇಟ್ಲಿ ಅರ್ಜಿದಾರ ಹೆಸರನ್ನು ಅನುಮೋದನೆಗಾಗಿ ಸಲ್ಲಿಸಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ. ಆದ್ರಿಂದ ಈ ಪ್ರೊಸೀಜರ್ ಟು ಪಾಸ್ ದಿಸ್ ಆರ್ಡರ್. This order was not set aside at all. That was a prayer. What is a prayer granted? What is the relief granted?
Public instruction. They have recommend. That is the
ಓದಿ ಅದನ್ನು ನಿಮ್ಮ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಚಾಲೆಂಜ್ ಪಾಸ್ಟ್ ಆಗ್ಲಿಲ್ಲ.
ಅದರಲ್ಲಿ ಅವರು ಮಾಡ್ಕೊಂಡು ಇದನ್ನ ಅವರು ಇದು ಮಾಡಿದಕ್ಕೋಸ್ಕರ ಅವರಲ್ಲಿ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾರೆ. ಹಾಗೆ ಕನ್ಸಿಡರ್ ಮಾಡಬಹುದು ಅಂತ ಮಾಡ್ತಾರೆ. Because DDPI has recommended the case of the petitioner. So far as he is not that doesn't matter because I have produced the document. I have the document 88/2022 when the DDPI was recommending the case of the petitioner. Petitioner case na
ಇದು ಹೇಳೋದು ಸಲ್ಲಿಸುವ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಶೀಘ್ರವಾಗಿ ಪರಿಶೀಲಿಸಿ ಅರ್ಜಿದಾರರ ನೇಮಕಾತಿಯನ್ನು ಅನುದಾನ ಸಹಿತ ಅನುಮೋದನೆ ಕುರಿತು ಕ್ರಮ ಕೈಗೊಳ್ಳುವಂತೆ ಪರಿಶೀಲಿಸಿ ಅಷ್ಟೇ.
next year.
Your post can be admitted to grant only if it is permissible under the rules.
Yes,
When you were appointed in the year 85,
yes, 86.
86, there are already two other people working.
That is, they have retired in the year 2015, they retired and ಅವರೇ recommendation ಮಾಡಿದ್ದಾರೆ.
2015 ಆದ್ಮೇಲೆ ರಿಟೈರ್ ಆದ್ರೆ fresh post ಬರುತ್ತಲ್ಲ vacancy that can't be filled up by way of aided post.
Then I have produced this agenda to that other document actually one way and give the clarification regarding what the institution was made. Till today that until April 2023 we go 23
ಅಲ್ಲ ನೀವು ವರ್ಕ್ ಮಾಡಿ ಅವ್ರು ಸಂಬಳ ಕೊಟ್ಟು ವರ್ಕ್ ಮಾಡಿ ಬಟ್ ಏಡ್ ಕೊಡಕ್ ಆಗಲ್ಲ.
ವರ್ಕ್ ಮಾಡಿ ಅಂತ ಇವಾಗ they given the recommendation to the authority.
You cannot be admitted to a salary grant. That is your prayer.
ನನ್ನ ಸಮಯ ನಾನು ಚಾಲೆಂಜ್ ಮಾಡ್ತೀನಿ ವಿತೌಟ್ ಏಡ್ ಕೊಡ್ತಾರೆ ವಿತೌಟ್ ಕೊಡಬೇಕು
ಕೊಡಕ್ ಆಗಲ್ಲ ಅಂತ ಬಿಕಾಸ್ ಒಂದೇ ಒಂದು ಪೋಸ್ಟ್ ಕೊಡಕ್ ಆಗ್ತಿದ್ದು ಅದ್ಯಾರು ಇಬ್ರು ಇದ್ರೆ ಆಗ್ಲೇ 2015 ಅಲ್ಲಿ ವೇಕೆನ್ಸಿ ಕ್ರಿಯೇಟ್ ಆಗಿದ್ರೆ ಆ ವೇಕೆನ್ಸಿ ಕಾಂಟ್ ಬಿ ಫಿಲ್ಡ್ ಅಪ್ by way of an aided post. ಎಷ್ಟು ವಯಸ್ಸು ಎಷ್ಟು ನಿಮ್ಗೆ ಈಗ? ಬಿಡಿ ಇನ್ಯಾಕೆ
more than 35 years he worked in that institution
ಮಾಡಬಾರ್ದಾಗಿತ್ತು ನೀವು ಬಿಟ್ಬರ್ಬೇಕಿತ್ತು. I cannot direct them to admit you to salary grant.
Issued by the institution.
ಕರೆಕ್ಟ್, ನೀವು ಸೇವೆ ಸಲ್ಲಿಸ್ತಾ ಇದ್ರೆ 2012 ಅಲ್ಲಿ ಕೊಟ್ಟಿರೋದವ್ರು.
ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ತೀರ್ಮಾನ ಅಂತ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಇದೆ. ಈ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿ ಅಭ್ಯರ್ಥಿ ಶಾಲೆ ಹಲವಾರು ಬಾರಿ ಪ್ರಸ್ತಾವನೆಗಳನ್ನು ಸರ್ಕಾರಕ್ಕೆ ಸಲ್ಲಿಸಲಾಗಿ ಹೆಚ್ಚುವರಿ ಹುದ್ದೆ ಹಾಗೂ ಆರ್ಥಿಕ ಮಿತವ್ಯಯ ಕಾರಣಗಳನ್ನು ನಿಧಿ ತಿರಸ್ಕರಿಸಿರುತ್ತಾರೆ. ಆದರೆ ಇತ್ತೀಚಿನ ಆದೇಶದ ಮೇರೆಗೆ ದಿನಾಂಕ 2/86 ಈ ಅಭ್ಯರ್ಥಿ ಅನುಮೋದನೆಗಾಗಿ ವೇತನಾಂಗಕ್ಕೆ ಒಳಪಡಿಸಲು ಹಾಗೂ ಪ್ರಸ್ತಾವನೆಗೆ ಸರ್ಕಾರಕ್ಕೆ ಸಲ್ಲಿಸಲು ಸಭೆಯ ತೀರ್ಮಾನಿಸಿದೆ. Thereafter they have given the recommendation in connection ಎಲ್ಲಲ್ಲಿ
ಆಗಲ್ವಲ್ಲ ಮೇಡಮ್, you can't be admitted to grant because there are already two other employees. 2009 ಅಲ್ಲಿ ರಿಜೆಕ್ಟ್ ಆಗೋಯ್ತು. 2012 ಅಲ್ಲಿ ಮಾಡಿದಾಗ್ಲೂ ಅದೇ ರೂಲ್ಸ್ ಇತ್ತು, ರೂಲ್ಸ್ ಅಮೆಂಡ್ ಆಗಿರ್ಲಿಲ್ಲ. You would still suffer the same consequence because one post was already admitted to grant. They could not have admitted the second post to grant. ಅವರು 2009 ನಲ್ಲಿ ಎಷ್ಟು ಕೊಟ್ಟರು, they couldn't have admitted you to grant. ನೀವು ಕೆಲಸ ಮಾಡ್ತಿದ್ರೆ ನಿಮ್ ಗ್ರಾಂಟ್ ಅದು ಕೊಡಕ್ಕಾಗಲ್ಲ, ಸ್ಯಾಲರಿ ಗ್ರಾಂಟ್ ಅದು ಕೊಡಕ್ಕಾಗಲ್ಲ. ಅವ್ರ ಹತ್ರ ಕೇಸ್ ಆಗಿ ತಗೊಳ್ಳಿ ನೀವು, ಇವರು ಸರ್ಕಾರ ಕೊಡಲ್ಲ ನಿಮ್ಗೆ ಅಷ್ಟೇ. ಡಿಲೀಟ್ ಮಾಡ್ಬೇಕಿತ್ತು ನೀವು. ಅಷ್ಟೇ ಅಲ್ಲ, ನೀವು ವರ್ಕ್ ಮಾಡಿದ್ರಿ ವರ್ಕ್ ಮಾಡಲಿಲ್ಲ ಅದಕ್ಕೆ ಹೋಗೋದಿಲ್ಲ ನಾನು. ದೇ ಕಾಂಟ್ ಅಡ್ಮಿಟ್ ಯುವರ್ ಪೋಸ್ಟ್ ಟು ಸ್ಯಾಲರಿ ಗ್ರಾಂಟ್ ಕ್ಲೋಸ್. I am only concerned with their endorsement which relates to admitting you to a salary grant, nothing more. No, you are not very consistent when it comes to her service. You keep dilly-dallying.
I also taken all steps possible to recommend them to grant.
You are not consistent in your stand.
ಬಿಡಿ
ಆಯ್ತು, ನೀವು ರಿಟೈರ್ ಆಗೋಗಿಲ್ಲ ಬಿಡಿ, ಇನ್ನೇನ್ ಮಾಡಲ್ಲ.
35 years is more than 35 years he worked in that.
The request of the management to approve the petitioner's post to a salary grant has been refused, and hence the petition is before the court. It is not in dispute that the management did forward a proposal for admitting the petitioner's post to a salary grant. However, by an order dated 24/1/2009, that annexure R6 to the counter by the state. This proposal was rejected on the ground that the school already had 2 Group D posts and the rules did not permit admitting a 3rd post to salary grant. It is thus clear that the principal reason for rejecting the petitioner's claim for salary grant was that there were already 2 employees whose posts were admitted to grant in the Group D cadre. It appears that a further proposal was made in the year 2012, and this has culminated in the impugned endorsement. In the impugned endorsement, it is stated that by virtue of the amendment to the rules in the year 2017, so the private aided institutions were required to resort to outsourcing, and the government would not admit any Group B posts to a salary grant. Since in this case, it is not in dispute that the claim for admission of the petitioner's post to salary grant was rejected on the ground that the institution had already had 2 posts admitted to salary grant. It is obvious that the amendment which came into being in the year 2017 will not be applicable, and the case of the petitioner will be decided only in accordance with the 2009 rules. In accordance with the rules which prevailed as on 2009. As already stated above, the rules which were subsisting as on 2009 clearly indicated that only 1 post could be admitted to a salary grant. And since this proposal of the petitioner for admitting to salary grant was rejected on the ground, there were already 2 Group D posts admitted to grant. It is clear that the petitioner's claim for being admitted to salary grant would be untenable. Consequently, there being no merit in the petition is dismissed.
Subject mark.
What is the response? Issue notice. AG to take notice for R1. Next will take notice for R2 and R3. Issue notice to R4 for the next date of hearing. Annexure D, Alva. Annexure E shall not be given effect on the way from it. It shall matter. Here for impediment. Not survey purpose. Date ಕೊಡ್ತಾರೆ. 2:30. If you want 4:30 any vacant date you take at 4:30, not at 2:30. ಯಾವುದು?
The petition of employment of party and classification, the import is away from the building. Now that's directly. There is a, I mean, observation, not to precipitate the issue. However, the next day, I have to issue this a note that if I am not, able to grab the action will be initiated.
Huh?
So, stay of the order.
What is improved note?
Chief page 78. Earlier, I was appointed as chairman of the department. I refer to the, so I want this point. I must announce that. I have it on Monday.
You have been appointed in this place.
Yes, sir. Also, the order is on the I have been appointed. Also, the order is on the
Maintain status quo till next week. Whatever is ನೀವು ಇದೀರಾ charge ಅಲ್ಲಿ. The other status quo but if they've issued a memo, you are not the person who has issued the memo. Therefore, I am saying maintain status. Therefore, I am granting them a status quo so that they don't take any precipitated action.
No, but I'm on Monday. Instead of
You may have time on Monday. I may not have time on Monday, so I'll have it released on so till then. Status quo to be maintained. I'll consider on the next date of hearing. I'll consider the next date of hearing. ಬರುತ್ತೆ ತಗೊಳ್ಳಿ ಎದುರ್ಕೋಬೇಡಿ ನೀವು. Yes. Recruitment, I normally can't grant a stay. So it's better that it's in B group so that if you get a chance, I'll get a disposal.
Serial number 17, application not directed to the matter for engineering for consideration of between there. Departmental inquiry not initiated. I have been dismissed from service when that is the highest penalty. And the last occasion on 18/11/2023, there is a direction to use the matter for preliminary. But if they are requesting on Monday or Tuesday, they are proceeding.
He'll give a date. He is the master of the roles. He knows which date is coming.
You are inquiry.
Court officer, remaining matters repeat, court officer.
Sir, hearing matters ಎಲ್ಲ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀವಿ ಸರ್.
Serial number 80 ಎಷ್ಟು serial number 80. Court officer serial number
11.
11 ಅಲ್ವಾ?
Madam, sir. Sir. 21. Serial number 32, sir.
ಸ್ವಲ್ಪ ಒಂದ್ ನಿಮಿಷ ಮಾತಾಡ್ತಾ ಇದ್ದಾರೆ.
Okay. Sir.
That's it.
ಇಲ್ಲ
ಅದು ಎಲ್ಲ ಒಂದೊಂದು ಡೇಟ್ಸ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಯಾವ ಖಾಲಿ
ಸೀರಿಯಲ್ ನಂಬರ್ 71 ಏನಾಗಿದೆ ಸ್ವಲ್ಪ ಹೇಳಿ ಸರ್.
12 ಬಂದ್ಬಿಟ್ಟಿದೆ.
ಸೀರಿಯಲ್ ನಂಬರ್ 92.
ಅದ್ ಸೈನ್ ಆಯ್ತು ಇವ್ರಿಗೆ ಅರ್ಥ ಇಲ್ಲ ತಗೊಂಡ್ಬರ್ತಾರೆ.
Sir, serial number 71 412 ಗೆ sir.
ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
Okay, sir.
ಸೀರಿಯಲ್ ನಂಬರ್ 92 ಏನಾಗಿದೆ?
1812 sir.
18. Thanks.
Remaining actions there. Orders. 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 Think ಮಾಡೋಣ ಸರ್. ಈಗ ನೀವು ಬರ್ಸ್ತೀರ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಬರಲ್ಲ. ಕಾಲ ಆಗಲ್ವಾ?